This meeting of the Public Utility Commission of Texas will come to order to consider matters that have been duly posted with the Secretary of State for April 17th, 2026. Good morning, everyone. Well, we've got a full house today. Commissioners, real quick, before we get going, just a couple of housekeeping items. I'd say we go in order except for we granted oral argument in item number 11. So I'd suggest we bring that up after we do item 13 so that everyone ahead of that case in the contested case dockets doesn't have to wait. I think we'll have quite a robust discussion on item number item 13 before item number 11. This way we'll have a robust discussion on item 11, and I don't want to have to make everyone sit and wait around for that if that works. Okay. Then today it's also worth noting for those of you who don't know, Davita Dwyer is going to be leaving the commission. Davita's over there. She's normally up there. And Davita, we're again, sad to see you go, like I told you privately, but excited to see what you go do next. That'll be a good move for you and your family, which needs to be the number one consideration anyone always has. So thank you for all the time you've been here. I don't know, you've come and gone, so maybe we'll see you back again. Everyone keeps trying to beat Tom Hunter's 4 or 5 times coming back. It's a record that stands the test of time, but maybe you'll be the one to achieve it. But good luck in everything you do next, and we've appreciated you. Thank you. And then last, for you math majors out there, 1, 2, 3, 4, 5. So we have a fully empaneled commission once again. So Commissioner Rhode, welcome. And, want to give you a chance to make some opening comments, but I don't know if Peggy told you when you accepted this job that the chair's prerogative is to haze you at your first meeting. I've done various things to everyone up here. Obviously, Kathleen was here before me, but I think for you, what we'll do is we have a couple really important issues that are somewhat contested. I think we'll let you lead on those issues this morning. And so really look forward to hearing your thoughts to help inform us.
It stays on.
It's on.
Is it on?
That's the hazing.
There you go. There it is.
Thank you very much. I've been called the fifth Beatle, and I think I'm appreciating why, perhaps. But, no, thank you very much. It's certainly an honor to be here, and I'm anxious to roll up my sleeves and get to work. So thank you.
Welcome. All right. Mark, with that, will you take us through the consent agenda, please?
Yes, sir. So by individual ballot, the following items are placed on your consent agenda. Items 4, 5, 6, and 7. And item numbers 10, 12, and 15 will not be taken up. And Commissioner Rhode is recused from item 4.
Thank you, Mark. I'll entertain a motion to approve the consent agenda as laid out by Mark.
So moved. Second.
I have a motion and a second. All those in favor say aye.
Aye.
Opposed? Motion prevails. All right, that'll take us then to item number 1, public comment. Mark, has anyone signed up for public comment this morning?
Yes, and Alex will detail that.
Right. We have 5 people who have signed up for public comment. In addition, 1 person has signed up for comment on 2 projects. That's items 23 and 25. So we'll take that up then. We'll start then with the public comment. I'll call up 3 of the 5 first. If you'll come up to the chairs beside me, that's Kevin Kennedy, Rock Morrell, and Joanna Friebele. And while they come up here, I'll explain that it's going to be 3 minutes, Chairman, for public comment.
Yes, sir. That's correct, Alex.
Yes, so when it's your turn to speak, introduce yourself by name so the court reporter can catch it. And I'll start your time. It's very good. Yeah.
Whenever you're ready, sir.
Yeah. Kevin Kennedy.
Kevin Kennedy. Good morning. How are y'all doing?
Good morning. Doing well.
So my name's Kevin Kennedy. I'm from Burnet County, the eastern end of Burnet County, and my property is directly impacted by 10 of the viable routes on the eastern end of Import Path 2. And I've always been just kind of fat and happy about the electrical grid. I hit the light switch and the light comes on, and I don't ever think about it much. But in June, I got an invitation to a public meeting in Lampasas. And I went and I learned that there was a proposal to run a transmission line through my property. So I thought, well, I better educate myself. So I started studying transmission, and I probably spent virtually every waking hour since that time till now to educate myself. And I've got the luxury of that, of having time to do that. And last week, my wife was out of town for a few days, and she called me and she said, "What are you doing?" And I said, "Well, I'm working on my dadgum power line." And she said, "Well, I should have known that." And she said, "I kind of hate to tell you this, but," she said, "all my friends, they've started to refer to you as Kilowatt Kevin." And I guess I've kind of earned that because my background is engineering, and so I understand this. So I've studied the reports, I've read the information, I've listened to what people said, I've educated myself about transmission lines, about load, about supply, and I've found a lot. And I feel like I probably know as much about this as anybody that I've talked to, at least anybody who's a civilian, anyone who's not directly involved. I know a lot, and I look forward for old Kilowatt Kevin to turn the lights on and to shine a bright light on this process and the steps that have been taken and the decisions that have been made and whether it benefits the public or not. And by turning that light on, I hope to provide y'all with the information you need to make a good decision, a good proper decision as the charge of this agency, and to hand that to you on a silver platter. And we may find that the Permian Basin Plan was maybe a feat of engineering amazement, and that the recommendations and findings in it are elegant solutions to these engineering challenges of this recently discovered demand growth in electricity. Or we may find that maybe it's got a few holes in it. And I'm going to work diligently to find that out and shine that bright light, a bright, intense, withering light of scrutiny. And I guess my suggestion is that everybody get them a pair of sunglasses and some good sunscreen, because old Kilowatt Kevin's going to turn the lights on. Thank y'all.
Thank you, sir, and appreciate that you're involved in one of the cases. Thank you for keeping your comments general. I'll say the same thing to everyone. If your comments are really geared towards a specific contested case that'll be before us, please don't talk about the specific merits of that. We'll have time during that process where we've committed to granting oral argument in those cases to talk about the specifics. This part of the conversation is really about general comments about process and things like that. So please do your best to stay away from the specific merits of any contested case. I appreciate your ability to do that, sir.
Great. Next, Rock Morrell.
Good morning. My name is Rock Morelli, and I own property in Burnet County. Your specific comments were news to me, so my speech is a little different. I'm requesting that the transmission line, the Bell County East Big Hill 765 kilovolt transmission line, be delayed. I'm concerned about the negative impact on the environment and the actual need for the proposed transmission line. In the ERCOT report on existing potential electric system constraints and needs, there's a definition that we are adding 44,000 megawatts of solar power and 31,000 megawatts of battery storage in rural areas, unpopulated areas of South and West Texas by 2028. The information we've received is that the proposed transmission line would not be completed until after 2029, after the 75,000 megawatts of generation is added to the Permian Basin grid. Additionally, the proposed transmission line can only carry 3,000 megawatts of power. So it's a trivial amount of power, exported from Central Texas that has no excess power to export, or if they do, it's not defined, to a place where there's going to be substantial excess power by 2028. Thank you for the opportunity to speak on this. God bless the state of Texas.
Thank you, sir.
Yeah, go ahead.
Chairman Gleeson and Commissioners, my name is Joanna Friebele from Erath County, and I'm here today to talk about 765 kV transmission lines. But first, I'd like to comment on the new proposed large load regulations and applaud you for working diligently with ERCOT to try to find a solution, to better understand the actual real need and how this affects our grid moving forward, and how that can be achieved to satisfy all parties involved, from large load customers to general public ratepayers. Will you acknowledge that the assumptions and statistics underlying the Permian Basin Reliability Plan, as developed 2 years ago, are flawed in light of the proposed regulatory changes? The only way to keep electricity prices from rising on a system with growing demand is to increase supply, not moving existing electrons around more efficiently, and having ratepayers on the hook for massive transmission build-outs. On a more local note, I'm proud of our community along the Dinosaur Longshore line for stepping up and making sure our segment was not ignored. With over 4,500 filings on the interchange list, landowners have come together remarkably well to voice their opposition of all lines in our counties. Oncor may have hoped to divide and conquer, but it did not work with us. But that still does not capture what this means for people directly affected. Many are struggling to understand what's happening to them, what it will mean for their land and their lives, what they can realistically do within the process to push back, to protect property values. The process is stacked against them. I know thoughtful, capable people who have crumbled at the prospect of preparing testimony and traveling to Austin for hearings. It is untenable for them, and they have no idea how to navigate it. You can see this in how many interveners never filed testimony at all, even though each of them had a story to tell. Landowners deserve to be treated far better and with genuine respect when their property rights, the very foundation on which Texas was built, are being taken from them. This system must change. If anyone believes landowners can ever be comfortable with the current process, they are mistaken. A plan like HB 5066, which affects so many people, should have undergone rigorous legislative oversight and robust public input before it was put in place. Regulators should not have the final word. A plan conceived by a commercial entity, heavily lobbied for by that same entity, then enacted into law, and ultimately awarded the lion's share of the project, appears fundamentally at odds with the PUC's regulatory commitment to guardrails that protect ratepayers. Thank you.
Thank you, ma'am.
Thank you all.
Thanks to all y'all for being here this morning.
The remaining two people who have signed up to speak in oral public comment are Jan Rose and Steve Davis. Could you both come up? You can begin.
Good morning, ma'am.
Thank you. I'm Jan Rose. I'm a Texas landowner concerned about the 765. Thank you for allowing me to speak. Recently, a group of concerned landowners met with the governor's policy staff. Though interested, they were quick to point out the governor did not shorten the approval time from 360 days to 180. That was done by the legislators. They did stress the governor has asked all involved to be transparent and helpful to Texas citizens, and they wanted to know what our opinion was. My opinion is it's been hard. In my case, our county judge and commissioners ignored the February 2025 notice from Oncor. Information was not passed to the citizens. So in June, letters were mailed by the transmission service provider in plain, nondescript envelopes. No identifying information to indicate the importance. Many never either received or just thought it was junk mail. Public meetings were held, some over 100 miles from where people lived. They were chaotic, there were no presentations, questions went unanswered. In fact, most people didn't know questions to ask, as this was the first time they were learning of a project of this magnitude. So for me, the next 11 months have been spent preparing, learning, asking questions, relying on neighbors, talking to legislators. But I must speak for those landowners who recently have been notified outside the study area. They have had 30 days to do what has taken me 11 months. They must educate themselves, find experienced counsel if they can afford it, but good luck with that. File as an intervener and understand and immediately act on this process. Let me leave you with an intervener who recently filed. Quote, apparently, after talking to Jeremy McConnell from Oncor, a leg of this project was added back in July 2025 after the conclusion of a public meeting. Living in Austin, we are limited as to what is going on in the country and the county we own land in, and we were unaware of this vast project to begin with, and more specifically, how we would be affected by the addition of this new leg coming through our property. We had no communication. Gilbert and Tina Rojas. So today I speak for them and so many like them. No, Governor Abbott, the agencies and entities have not been transparent and helpful. Thank you.
Mr. Davis?
Thank you. My name is Steve Davis, and I'm not at all sure I'm in the right place. I'm here for docket number 57386, and this has nothing to do with electricity. This is wastewater and water. Am I in the right place?
Sorry, 57386. Mike? Maybe we can. Appears to be, I see, that appears to be item for it. Because I think that item is an agenda item. You could speak about it generally,
could
but
I?
not about the specifics of the case.
Not about the specific. Okay, I apologize for taking your time. Obviously,
no
I'm
need to
not in the right
apologize.
place.
So I would say the same kind of rule applies. So that's actually a contested case. So if you want to talk about the policy in that case, generally that's completely fine. But we're not going to get into the specifics of that individual case.
Okay, could I
Yes, sir.
speak to that?
Yes, sir.
All right. I'm retired. You can tell by the way I dress. I apologize to everybody in a suit and tie. But I bought a place down on the coast outside of Palacios called Boca Chica. And the water company there was taken over by a company called CSWR-Texas Utility Operating Company. When I bought my place down there, the idea was to prepare myself for retirement, fish a lot, and just relax. And I've done a lot of that. But when I moved in down there, the utility cost was based at $57 a month base. Didn't matter if I used water or sewer or not. That's what you paid to have the luxury of having it available. Since that time, it has increased to $172. There has been no improvement in service. Water quality is still to a point where I won't drink the water. I usually mainly wash my boat and to do chores around the house with, but I wouldn't drink it. I don't understand why they have the right to increase from $57 to $172 for no apparent reason in my mind. It's a hardship on me. I'm looking at probably having to sell my place down there that I'd planned on doing a lot of fishing in retirement, And it just seems to me like there should be a law against it. And I imagine that if there is, you would know what it is. I don't. I'm not a lawyer. I'm a retired builder. But I do have something to say, and I just said it. So I hope that doesn't fall on deaf ears, and I appreciate the time. Thank you very much.
Thank you both for being here this morning.
Thank you.
I was just going to mention, if you wanted to speak with Mike Hoke, where is Mike? I saw him in the back of the room earlier. He might be a good guy to walk through some of the PUC regulatory stuff and how engagement with public works. He's got some real good information.
Okay, thank you very much.
You got it.
Thank you, Commissioner Johnson, for that as well. All right, Alex, that concludes public comment.
That concludes public comment.
All right. Then we'll go to item number 2. Mark, will you lay out item number 2, please?
Item number 2 is docket 57249. It's a complaint of Lindsay and James McCellon against Undine LLC. And what is before you is Commission staff's appeal of SOL Order Number 9 on the correction of jurisdictional defects. And DICE filed a letter brief in response to SOL Order Number 9 on correction of jurisdictional defects.
Thank you, Mark. So the SOA judge concluded SOA lacks jurisdiction here to hold hearings in water complaint cases that were referred by the PUC. I think the SOA judge got this one wrong, and I would grant the appeal and reverse the order, but I'm interested to hear what you all think on this.
Yeah, I'm happy to take a stab. Clearly, I think it's clear on the law for this, and that's to grant commission staff's appeal. First, DICE does not have different specific jurisdiction than the PUC as an agency as a whole. It gets its jurisdiction from the agency. And I take issue with another state agency trying to direct our internal divisions and what they should do. Second, unless we conduct the hearings ourselves, SOA is required by their enabling statute and ours to conduct these hearings themselves. They have done this for years, so where it came from that they start to question that now, I'm not sure, but I would agree with you, Mr. Chairman, on granting the appeal.
Yeah, I think I'm just going to echo that as well. I think water code and then SOA's enabling statutes clearly articulate when PUC has the authority to obviously grant a hearing request or to decide when a hearing is proper. And pursuant to statute, it's real clear that SOA then holds those hearings, adjudicatory hearings specifically for us. But I will say that I appreciate the opportunity that they highlighted, but coincidentally, staff, actually, when I joined the commission, had already been in the process of looking at our complaint process to ensure we could really streamline and make it efficient for consumers, utilities, and all parties involved, which I think we're going to talk about in a little bit in one of our rural projects later. But, yeah, so I think while they highlighted an opportunity we have, staff had already been diligently working on it. So I appreciate staff having the foresight on that.
Yeah, I appreciate, as you said, staff having the foresight on that. I also would grant the appeal and grant all the relief that is sought by staff.
I agree.
Okay, well, if there's no more discussion, I'll entertain a motion to grant commission staff's appeal consistent with our discussion.
So moved.
I second.
I have a motion and a second. All those in favor say aye.
Aye.
Opposed? Motion prevails. Mark, lay out item number 3, please.
Item 3 is docket 57268, complaint of Elaine Mendoza against Undine, Texas LLC on the order on appeal of SOA Order Number on correction of jurisdictional defects. And before you is the commission staff's appeal of the SOA order, and DICE filed a letter brief in response to SOA order on correction of jurisdictional defects.
Thank you, Mark. Commissioners, I think our discussion on item number 2 covers everything we'd need to discuss on item number 3, unless you believe there's any issues that we need to talk about.
And here.
Okay. I'll entertain a motion to grant commission staff's appeal consistent with our discussion and our decision in docket number 57249.
So moved.
I second.
I have a motion and a second. All those in favor say aye.
Aye.
Opposed? Motion prevails. Mark, that'll take us to item 8. Will you lay out item number 8, please?
Yes, docket item 8 is 55299, application of Centrio Solutions LLC and Santa Rosa Telephone Cooperative for approval of a CCN in Baylor, Clay, Childress, Cottle, Ford, Hall, Hardeman, Haskell, Knox, Motley, Stonewall, Throckmorton, Wichita, and Will Barker counties. Before you is a proposal for decision. No parties filed exceptions or replies, and the chairman filed a memo.
Thank you, Mark. So Commissioners, my memo modifies conclusion of Law 8 and adds new conclusions of Law 6A and 8A. Happy to answer any questions or hear your thoughts.
I appreciate you clarifying the grounds for dismissal, and I'm supportive of your memo.
I'm supportive of your memo as well.
Agreed.
Agreed.
Okay, I'll entertain a motion to adopt the PFD in part and reject in part consistent with my memo.
So moved.
I second.
A motion and a second. All those in favor say aye.
Aye.
Opposed? Motion prevails. Mark, will you lay out item number 9, please?
Item number 9 is docket 58306. It's the application of Oncor Electric Delivery Company for authority to change rates. On March 18th, the docket management ALJ filed a proposed order. Oncor and the Rep Coalition filed exceptions, and the docket management ALJ filed a revised proposed order on April 13th. The chairman filed a memo.
Thank you, Mark. Commissioners, I appreciate the parties coming together and bringing us an agreement in this rate case. My memo just has a few minor changes in the proposed order. Happy to take any questions or hear your thoughts.
None here.
No, I too agree that reaching the unopposed settlement is great, and I think it is a good outcome for ratepayers with what they came up with, so I agree with the changes in your memo.
I did look through the settlement, and I'm in agreement that it's good for the ratepayers, and appreciate the settlement, as well as agree with the changes in your memo.
All right, with that, I'll entertain a motion to approve the revised proposed order consistent with my memo.
So moved.
Second.
I have a motion and a second. All those in favor say aye.
Aye.
Opposed? Motion prevails. Mark, will you lay out item number 13, please?
Yes, sir. Docket item 13 is 59182. It's a joint application of Oncor Electric Delivery Company and LCRA Transmission Services Corp. to amend their CCN for the Big Hill to Sand Lake 765 transmission line project in multiple counties. What is before you is an appeal of SOAR Order Number 15 by Judy Gracie, Kevin Kennedy, Tom Green, and Mark Friesenhahn. Commissioner Yaltman filed a memo.
Thank you, Mark. Commissioner, would you like to lay out your memo?
Sure. At our last open meeting, we did issue an interim order outlining some criteria to determine the standing of parties in these type of cases. As I lay out in my memo, I think Mrs. Gracie and Mr. Kennedy clearly met those criteria. There is a common point of intersection for both the CCN cases and that are pending before the commission, and they are clearly directly affected. However, I recommend we extend time to consider the appeals of Mr. Green and Mr. Friesenhahn. Public participation in these cases is critical, and I'm sympathetic to the fact that they are very confusing and can be daunting, as even some of the testimony this morning laid out. So I think it would be fair to allow them a little more time to submit some evidence to consider, and we can take this up at our May 7th open hearing meeting. And then finally, given how far along this case is, I do recommend we deny Mr. Kennedy's addendum. The ALJs are in the best position to decide how the parties can participate. So with that, I'm happy to answer questions or make a motion.
Thank you, Commissioner. I appreciate the memo. I agree with it. Commissioners, any questions?
Here.
And here.
You sure, Patrick?
Would you like to make a motion?
Sure. I move we grant the appeals of Mrs. Gracie and Mr. Kennedy and extend time to consider the appeals of Mr. Green and Mr. Friesenhahn. I also recommend we deny Mr. Kennedy's addendum consistent with my memo and discussion.
I second.
Have a motion and a second. All those in favor say aye.
Aye.
Opposed? Motion prevails. All right, that will take us then back to item number 11. Mark, will you lay out item 11, please?
Item 11 is docket 58881, application of Crusoe Energy Systems, FGE Goodnight, and Ensign Infrastructure LLC for approval of a net metering arrangement. Commission staff, Goodnight, and Ensign filed corrections and exceptions to the proposed order. The docket management ALJ adopted in part commission staff's exceptions and made no changes in response to Goodnight or Ensign's exceptions. For your consideration is a revised proposed order filed on April 14th. Oral argument was granted. The chairman filed a memo.
Thank you, Mark. Commissioners, as I said in my memo, I'd allow the parties 10 minutes, except in cases where the parties filed jointly. So Ensign, Crusoe would get 10 minutes jointly, and Golden Spread, Greenbelt would get 10 minutes jointly. All the other parties would get 10 minutes independent. Does that work?
Works for me.
All right.
Right, we do have 5 parties signed up for oral argument. I think we have room for everybody here. So if the 5 parties could come up, that's Ensign, Goodnight, the co-ops, staff, and ERCOT. And as noted by the chairman, 10 minutes. The co-applicants are Ensign and Goodnight. My understanding is you've already arranged who would open first and close first? Okay. And then staff, I assume you reserve the right, even though staff has signed up to speak fourth, we'll take you up after the co-ops and ERCOT. Is that right?
Yes.
Okay. Do you have an idea of how much time you'd like to reserve if you want the help of the?
I think 2 minutes. Yeah. I'm sorry, 2 minutes. Katie Coleman for Ensign.
Great, then, yes, go ahead.
And just to clarify, I'm going to speak on behalf of Ensign and Crusoe, and then I think the only other, the other applicant is Goodnight, and Juliana's going to do that for Goodnight, but we're co-applicants. Ready? Okay. Thank you, Chairman and Commissioners. Katie Coleman on behalf of Ensign. Before you is the first contested case under the new provision of Senate Bill 6, which was adopted last session, that requires your review and approval of a proposal by a large load customer to site with an existing standalone generator. The facts in this case are not in dispute. In fact, we did not even hold a contested hearing. The facts are agreed upon by all parties. What is really before you is a policy question and a statutory interpretation question. The question is, in these SB 6 cases, will the conditions be based on the specific facts of the case, or will there be a uniform set of requirements that apply to any single load that is in a co-location arrangement that requires SB 6 review? Ensign submits that the statute requires you to consider the specifics of each case. Reading from the statute, the Commission shall approve, deny, or impose reasonable conditions on the proposed net metering arrangement as necessary to maintain system reliability. There is one specific requirement if it is a dispatchable generator. If it is a dispatchable generator, the Commission must require an equal amount of dispatchable capacity to be made available at the direction of the independent organization in advance of an anticipated emergency condition. Aside from that condition, the statute just requires you to consider the specific facts presented and tailor reasonable conditions as necessary to maintain system reliability. In this proceeding, this is a wind generation facility. It's an intermittent generation facility, so this dispatchable provision does not apply. ERCOT's own report found that the proposed transaction results in no stranded or underutilized transmission assets, no thermal voltage or planning criteria violations due to the addition of the load, and a de minimis decrease in the expected planning reserve margin of less than 1% across all forecasted seasons from spring 2026 to winter 2030-31. In essence, they found no reliability impacts specific to this arrangement. And yet, ERCOT is proposing that the Ensign load be required to completely curtail with 30 minutes notice in anticipation of any emergency conditions as determined by ERCOT in its sole discretion, that the Ensign load be prohibited from participating in any other demand response programs or ancillary services, and that ERCOT will have the ability to adopt future protocol changes that would apply to the Ensign load that could be completely inconsistent with the conditions imposed in this proceeding. Essentially, that any subsequent changes to the ERCOT protocols that would directly affect a load in this situation would apply to Ensign. I would submit to you that based on the record here, there is really no evidence to support a curtailment condition, period. Again, this is a renewable generator. ERCOT's own report found that there are essentially no impacts to the system. However, Ensign has put forth a proposed set of requirements that they would be willing to abide by. The main one is that for curtailments, they would like an objective standard, and they have proposed 3,000 megawatts of PRC to limit ERCOT's ability to curtail them early and often with no, guiding parameters. They are willing to curtail in response to a 30-minute deployment notice if they are given an hour of advance notice. And the reason for that is they need to pre-position the site to deploy. The deployment itself is very quick, but they have to get personnel out there. They've got to evaluate the status of the processes that are being run in order to preserve those processes, and that takes some time. And so they are willing to comply with the deployment instruction of 30 minutes if they have advance notice. They do not want to be excluded from ancillary services and do not believe that the record justifies that. Ancillary services and ERCOT's demand response programs have heightened requirements that could provide incremental benefits to the system if Ensign sought to participate in those. There doesn't seem to be any reason to exclude them if the load will, in any event, be off before any other customers are subjected to firm load shed. Ensign would like to only be subject to future protocol changes that are not in conflict with the order issued here. In other words, they do not want to be have an open-ended set of conditions that ERCOT can change by protocol indefinitely. And they would like to have a standard that the conditions imposed in this proceeding will automatically terminate in 5 years unless a case is made that they need to extend beyond that time. So those are the issues before you today, and as I mentioned, I think the issue really is this going to be a one-size-fits-all, regardless if it's a wind generator, regardless if it's a dispatchable generator, regardless of ERCOT's reliability assessment, regardless of the load's capability, or will these cases be tailored to the specific facts presented? And we would ask that it be the latter. Thank you.
You have 4 minutes, 23 seconds remaining. Next, Goodnight.
Chairman, Commissioners, good morning. Juliana Surson for FGE Goodnight 1 LLC. I'll be referring to Goodnight as just Goodnight for these purposes. As Katie noted, this is the first case under Senate Bill 6. In that sense, it is both narrow and consequential. It is critical that the Commission adopt a framework that is grounded in statute, supported by the record, calibrated to advance rather than undermine policy objectives of Senate Bill 6 without imposing conditions that extend beyond what is necessary to achieve those ends. Against that backdrop, the Commission's authority is defined and limited. As reflected in the record and under statute, the Commission must select one of three outcomes: approval, denial, or the imposition of reasonable conditions. Any such action must be tied to reliability impacts that were identified through ERCOT's study process and are necessary to maintain system reliability. These conditions must be grounded in the record and appropriately calibrated to address identified impacts. The record here is clear on that point. ERCOT's study concludes that the proposed arrangement can be operated reliably, independent of conditions. No witness testified that those mechanisms require Goodnight to assume responsibility for the load's conduct. No party identified a reliability deficiency that arises absent joint responsibility. And the proposed order itself acknowledges that operational control over the load resides with Ensign. That matters because some of the conditions at issue here do not operate within the statutory framework. However, as Katie noted, Ensign is willing to comply with certain conditions, but requiring the generator, requiring Goodnight to ensure that the load's curtailment or restrict the load's participation in ERCOT programs is not a requirement of the statutory framework. It is a reallocation of responsibility. It shifts load side obligations, which the statute assigns specifically to the retail customer, onto a generator that does not control the conduct. PURA 39169D does not authorize the commission to create the type of compliance relationship or make the generator a guarantor of third-party actions. There's also a fundamental burden of proof issue here. Under the commission's procedural rules, a party seeking to impose a condition bears the burden to demonstrate that the condition is supported by the record and necessary to maintain reliability. The burden rests with ERCOT and commission staffs for the conditions they propose. It does not require Goodnight to disprove speculative assertions about influence or viability, and that burden has not been met. The justification offered is not grounded by evidence of reliability or need. The justification, rather, is grounded in administrative convenience and generalized assertions regarding communications through a QSE. The record establishes QSE's functions as a communications interface. Curtailment requires action by the load, not the generator. There is no statute, rule, record evidence establishing that Goodnight has the authority or ability to direct or enforce the load's conduct. Administrative convenience cannot substitute for statutory authority. Speculation cannot satisfy a preponderance of the evidence. Yet the proposed order effectively reverses that burden by imposing joint responsibility without evidentiary support and requiring Goodnight to demonstrate why it should not be liable for conduct it does not control. This is not consistent with the procedural rules. Where findings of fact are not supported by a preponderance of the evidence, or where the law has been improperly applied, the commission is obligated to modify the order. Here, the record does not support the conclusion that joint responsibility is necessary to maintain system reliability, nor does it support assigning compliance obligations to a party that lacks operational control. Imposing such a requirement would effectively convert the generator into a guarantor of third-party conduct, introducing obligations that are not contemplated by the rules, by the statute, and that cannot be audited or enforced through existing compliance mechanisms. The path forward is straightforward and consistent with both the statute and the record. The commission can approve the agreement with conditions that align with responsibility and control. Load bears the responsibility for curtailment and participation decisions. The generator remains responsible for the generation obligations, as well as a disconnection backstop, because the generator controls the breakers along with the DSP. That structure satisfies the statutory standard, preserves system reliability, and supports the type of integrated development that Senate Bill 6 was intended to enable. To the extent the commission seeks additional assurance regarding load performance, a more appropriate and established mechanism for the large would be for the large load to establish a relationship with a QSE, consistent with existing ERCOT constructs such as emergency response service, where load resources participate through a QSE and are directly accountable for performance obligations. That approach aligns responsibility with control, provides ERCOT with a direct compliance interface, and avoids imposing obligations on parties that lack the ability to perform them. For these reasons, we respectfully request that the commission modify the proposed order to remove the assignment of load side responsibility from Goodnight Wind, align any conditions with the evidentiary record and statutory framework, and if necessary, direct that the load side obligations be implemented through structures that place accountability with the load and its QSE. Thank you for your time.
Thank you. Goodnight Wind, you have 3 minutes, 21 seconds remaining. Next, Golden Spread and Greenbelt Electric Co-ops.
Yeah, right here, thank you. Chairman Gleeson, Commissioners, thank you for granting the request for oral argument and taking the time to listen to us talk today. And hopefully, and hopefully understand all the topics a little bit better. My name is James Guy. I'm the General Counsel of Golden Spread Electric Cooperative, and also appearing today on behalf of both Golden Spread and Greenbelt Electric Cooperative. Greenbelt Electric Cooperative is a distribution cooperative, and one of the owners of Golden Spreads. We have 16 different owners. We're basically, as the G&T, the Generation and Transmission Cooperative, we're their generation partner, their transmission partner. Distribution cooperative serves the retail customers. For the newer commissioners, I know you all know that, but generally paying a little bit of background for the newer folks. It's been a while since I've been before you, since I've been up in Amarillo, and so I do want to acknowledge, especially as I was preparing to speak to you today, you guys and your staff have been incredibly busy implementing everything coming out of Senate Bill 6 and trying to coordinate all this, and definitely appreciate it. Largely doing a fantastic job on that. Electric co-ops are different. One of the most significant distinctions is the business model. Essentially, we are owned by, the distribution co-ops are owned by the retail customers they serve. They're not for profit, and because of that, because they're not for profit and they're owned by the retail consumers, which we call member consumers or members, we work real hard to earn the trust of those members, to collaborate with those members, to make sure we're serving them the best way we can. We communicate often, largely in person, at coffee shops and throughout the entire community. We work to understand the local issues and implementing what they need done. And in this case, we're largely involved in this case to support one of our newest members, Crusoe, now Ensign, as the owner and future member of that area, or current member of that area. So we are here and we support everything that Ensign has raised in their pleadings in this case, everything Katie Coleman just mentioned a few minutes ago, because that's the primary reason we're here. Being involved in the case, we did raise two issues that we noticed as we were looking at things. One is we raised a jurisdictional issue. As I mentioned, co-ops are different as being member-owned. They're also different because largely this commission does not regulate the way the co-ops can serve its retail customers. Unlike in the competitive areas of the state, where there are lots of regulations, and this commission really sets the policy and the rules for how the retail electric providers serve those customers, the legislature has set aside and have given co-ops the right to do that. So in this case, when we're talking about shedding retail load, when we're talking about telling retail load what to do, the initial reaction to that is it looks like it's interfering with what the co-op has the exclusive right to do. I think in going, and so we had that jurisdictional issue we raised. I think we also have some practical implications from that. And I think on the practical implications, what I mean by that is, in this case, ERCOT in the proposed order is requiring the generator and the retail load to shed under certain conditions. We've also required that load to shed under certain conditions. They're different than your conditions, or different than conditions you're likely to adopt today. So the initial reaction was, well, that's our right to determine when and whether that load sheds and how it sheds. I think after looking at this, looking at the proposed order, and looking at the testimony, just kind of look, I think largely I'm comfortable with the jurisdictional concern. We don't have as many concerns there because looking at some of the related Senate Bill 6 provisions and the rules and how it's coming out, what I see you're primarily doing with this case, what we're doing in this case, is largely a generation issue, right? You're dealing with an existing generator that's a wholesale generation connected to the grid. And what this order largely intends to do is we need that generation back on the grid at certain points. And that necessarily requires you to curtail the retail load to do that, in theory. So I think that's a fairly narrow exception. And then also looking at some of the other provisions, 39170, 39, my notes here are not very good, don't know the statutes here, 370561, recognize that this commission in other large load interconnection processes is not allowed to sort of circumvent what the co-ops have the right to do when it comes to serving retail load in other instances. So I feel like we've got the protection jurisdictional. I think the legislature has acknowledged that. So not that I'm glad we raised the issue. I'm glad that folks are aware of it, but I think I'm fairly comfortable that that's okay. The practical issue that we're dealing with, ERCOT has actually addressed largely in its reply brief, in its recommendations in the proposed order. We did not file exceptions to the proposed order. We support approval arrangement, obviously. We support what Ensign has to say. But our concern from a practical perspective was broader and has to do with the transmission owner's obligation to shed load in the case of emergency emergency events in the future. So, and our concern there generally has to do with, it's unique to co-ops a little bit, But, for example, Greenbelt Electric Cooperative largely serves members in the Southwest Power Pool. But because this generation facility is located in Greenbelt service territory, it does provide auxiliary power to the generation. And because the load is within that geographic service area, they are a member, the load, Ensign is a member of Greenbelt, even though it's ERCOT. So once this load gets on and running, to the extent it triggers a load shed obligation because it runs during peak times, then Greenbelt gets a load shed obligation because of that load, and they have no other ERCOT load to shed. So if this load has been shed earlier by ERCOT, Greenbelt's facing a situation where they don't have any other ERCOT load, at least today. I mean, I suspect they're going to have more, but they largely don't have. They have a very small amount of ERCOT load and nothing to shed. So it's a practical implication, it's a compliance issue, and it has to do with how the protocol set up load shed obligations. And in fact, internally, it's a golden spread issue. We allocate them across our 16 members how we're going to shed that load. So not only does Greenbelt not able to shed the load, now you got the other 15 members that have to find grandmas, grandpas, kids, residences to shed because of a decision that might be made in this case. I think ERCOT recognizes that. We've been talking to them about it. And the language they propose that says that the transmission operators, the table that you use to determine the load shed obligations, if this load is shed under this kind of order, then we will adjust that table to reflect that this load has already been shed. So it takes into account that previous obligation. I think that adequately addresses our concern on that point. Devil's in the details, of course, but I think ERCOT has done a fantastic job thinking about all of these issues as well, and they've been working with us on all the large loads we've been dealing with, so I'm confident that we'll be able to work that out in the future. I'm happy to answer any questions, but I guess that's where we land.
Thank you. Next party signed up to speak, ERCOT.
Morning, Chairman, Commissioners. Nathan Bigby with ERCOT. There are a lot of issues in this case, and I think this case has been very helpful at sort of narrowing these issues as the proceeding has moved forward. As the co-ops have just indicated, I think there's been some narrowing even at the stage of reply briefs, and that has resulted in changes to the proposed order that, from our perspective, make a lot of sense. I think we agree with Ensign that there is fundamentally a policy question. Maybe it's a legal question too, but it's a question about how to construe what the legislature was trying to do with the statute. Were they looking at setting up a paradigm of bespoke conditions for potentially dozens of net metering arrangements that we may see over time, or were they looking at potentially allowing flexibility for a set of standardized conditions? We did a lot of thinking about this after SB 6 was adopted, and as y'all may recall from the discussions we had back in August and September, bearing on the implementation of the net metering rule in 58479, our expectation was we were going to have to come up with some kind of a standardized curtailment paradigm so that we can handle the number of loads that may end up being put in these sorts of curtailment buckets. I think that Ensign's raised a number of questions about the wisdom of that approach in general, and I think it merits us talking about those. So I'd like to briefly address some of the issues they raised. But I think it's helpful to step back and look at the statutory design overall. From our perspective, there is a requirement that the Commission ultimately assess reliability and consider conditions that are necessary to maintain system reliability, including transmission security and resource adequacy. Those are the terms from the statute. And we think that the focal point there was on reliability, making sure that when you add these large loads at existing generation sites, that does not cause harm to the incumbent load on the system, that load should be able to use the generation that is essentially being removed in the parlance of the statute when you add that large load there. From our perspective, the only way to do that is to impose the conditions that are contemplated explicitly in the statute itself. It doesn't require them, but it does authorize the Commission to impose those conditions. And those are curtailment of the load and making the generation at the site available. And that's exactly what we have proposed in Condition 1 of our proposed recommendations. And I think it's important to note that our recommendations were narrowly tailored, right, to address only the situation where you have the most exigent risks on the system. So when we're facing down an EEA situation or a transmission emergency, only then would we have the ability to direct curtailment of these loads. We're not talking about using these loads because the generation might be cheaper to serve the grid, or it might be an easier way to resolve a transmission constraint on the system, right? SCED could easily use that generation. We could have argued that's a more efficient paradigm to enable the use of that generation on the grid. That's not our argument. Our argument is, let's let the data centers come, but only when we have a really extreme situation happening on the grid, an anticipated EEA or a transmission emergency, should we have to call upon this generation to help us out and get the load out of the way. We think that's consistent with the overall design of the statute, because what other purpose would there be in passing a bill that required the commission to ensure that the reliability is preserved when you add a load at a generation site? Now, a lot of the focus here is on the outcome of ERCOT studies, right? I think there's a lot of discussion last summer about, what is the point of these studies? What should ERCOT be looking at? And I think it's helpful to think through kind of those two studies that we did in this case. First of all, we basically looked at the Oncor interconnection study, did a review of that, and essentially endorsed that as the transmission security study. And I think there was consensus industry-wide when we started talking about this in the net metering rulemaking that that's the best way to do it, right? If you're going to look at transmission security risks, the interconnection study should be sufficient to evaluate that. But that study is not looking at the universe of transmission security risks. It is looking at a narrow set of expected circumstances, normal operating conditions, some contingency conditions, the conditions that you expect to cover the vast majority of operating conditions, no doubt, right? The studies need to be looking at what we expect the grid to look like. But the reality is you can never rule out the possibility that there could be edge conditions, contingencies, outages that you didn't project in those studies, because that's just the nature of real-time operations. No interconnection study is going to be comprehensive in evaluating all those conditions. That's just the nature of those studies. And that aligns with Prabhu testimony in this case, where he said, just because we didn't find any issues in the interconnection study doesn't mean that there isn't any real-time operation risk, right, associated with this load. Right? It might suggest that there is a lower probability that we'd ever need to call on curtailment. And that should be an important consideration here, because that really undermines any argument from Ensign that there's a real risk of curtailment if they're right that there isn't any reliability issue here. Right? Why would we ever need to curtail them if they're right that the studies show zero risk? The reality is, of course, that there's always a possibility that something could happen on the grid. You could always have an outage, you could always have a contingency. That puts us in a position that was not consistent with what we found in the interconnection study, because that wasn't evaluated. And in those cases, you need to have the flexibility to ask for that curtailment in order to ensure that load is held harmless from a reliability perspective. And they've argued a similar point on the resource adequacy front. They've pointed out that we had a 0.7% impact in our planning reserve margin study, and they call that de minimis, right? That's, I think that's subject to debate. That's almost a 1% impact on an 85 gigawatt grid. Setting that aside, we're not taking a position on that, right? And the commission has not established a firm threshold on, what bar do we set when a load addition does create a resource adequacy problem. That may be an issue that this commission needs to wrestle with at some point. But at this stage of affairs, we're just quantifying what that impact was. That was the purpose of the study. Give the commission that context so they understand, what each of these load additions is doing in terms of the planning reserve margin. But when it comes down to it, we don't need to impose a condition that's based on any particular threshold there, as long as we have the right to direct that curtailment whenever we're facing down a capacity shortage, an EEA situation, right? And so we've designed these conditions to avoid conflicting with these commercial interests to the greatest extent possible, because it's only a 30-minute window. So you have the flexibility up to that point where we say, look, we're thinking we're going to hit an EEA condition. We need you to get out of the way so we can get this generation, to serve the incumbent load on the grid. We think that's the design of the statute. And so that's the least obtrusive means to achieving the reliability ends in the statute that we believe. Now, one of the other issues that Ensign raises is the fact that they're a renewable generator, and so this whole paradigm of curtailment and making the generation available shouldn't apply at all. We don't think that's the right read of statute. We think that results in a discriminatory outcome. It would discriminate in favor of renewable resources against dispatchable resources on the grid, and we don't see any good reason to do that. If you have an EEA situation, for example, and you've got 265 megawatts of load that you've added at this existing generation site, then getting the 265 megawatts of load off the grid will always help you, right? And no matter what the generation value is, whether the wind's producing 30 megawatts, 100 megawatts, 260 megawatts, all that generation is going to help, whatever it is, and getting the load off the grid is going to help, no matter what it is. So there is clearly a reliability benefit to adopting these curtailment conditions regardless of the real-time output of the wind. There's really no reason not to impose the same kinds of conditions on renewable generators that you would on dispatchable generators. We concede the statute requires that the commission direct that dispatchable generation be made available to the grid in advance of EEA conditions, but it also authorizes the commission to do the same thing in every other circumstance. And so we don't think that should be a legal limitation. And with the discriminatory concerns that you have with limiting that to dispatchable generation, we think that's a strong reason to adopt that as a standardized policy. And that's what these are, standardized recommendations. We think these are replicable policy recommendations that can be repeated in every single case. You have a standard 30-minute curtailment directive with an option for 10 minutes, right? That would further insulate you, further protect you from the risk of having that directive and give you even more flexibility if you're capable of and willing to curtail in a shorter period of time. There are loads that are willing to do that, and we expect that there may be others that might opt for that shorter period. We had initially preferred a 10-minute curtailment, I'll add, but decided that it was helpful to recognize that there may be some loads that want a longer period of time. We wanted to give 30 minutes. We have a lot of products, right, that curtail at 30 minutes, 30-minute ERS. We have non-spin. We have the voluntary early curtailment loads that are curtailing at 30 minutes that the co-ops mentioned. This would fit within that framework. 10 minutes also fits because we have other products that curtail at 10 minutes. But when you push things back to 60 minutes, we're really increasing the risk, right, that we're not going to be able to respond in time. I see our time's up.
Thank you. Last party signed up to speak is Commission staff.
Floyd Walker with Commission staff. Good morning, Commission. Just want to say that PURA 39169 requires the Commission to consider the impacts that the proposed net metering arrangement will have on system reliability in determining whether to accept, deny, or impose reasonable conditions on the proposal. The burden, if any, on the applicants is an entirely separate matter. Regardless of whether the large load customer designed its system to curtail quickly or slowly, the initial reliability impact of the system is the same. The conditions needed to mitigate the system impact are not customer specific. So talking about the facts, there's the facts of what the impact on the system is versus any individualized concerns. Here, Ensign seeks to dedicate up to 265 megawatts of generation to its load. ERCOT says that the system reliability impact of that can be mitigated if the load can curtail within 30 minutes. Ensign claims that it would be unduly burdensome by a 30-minute curtailment obligation, but even if there were evidence to support that claim, it would not lessen the impact on the system. 30 minutes is an objectively reasonable amount of time to curtail, and there's nothing in SB 6 or 39.169 specifically that requires the Commission to accommodate the extra time demanded by the Ensign load. And it's also important to recognize that the systems are still being developed and that the curtailment condition in this case could be thought of more as a prototype that's expected to be formalized later in ERCOT protocols. And there's nothing inherently wrong with crafting the conditions with that understanding. For example, the current communication flow of a curtailment instruction is from the generation resources queasy. ERCOT will contact the generation resources queasy, and then through a process that's actually not specified, the load will be contacted, and then presumably curtailment will happen in 30 minutes. So if once the systems are developed, it may be possible or preferable to contact the load directly. It may have its own queasy, and that's why Condition 2 is important, so that it can be adapted to these later protocol revisions. And that's the kind of thing we're contemplating is, working out details rather than the substantive change to something like the 30 minutes. And regarding low participation with other services, it's important to recognize that, again, the systems are being developed. Therefore, it's unknown whether a load with a curtailment obligation can safely provide other services consistent with that obligation. Therefore, it's appropriate to defer resolving that complication until a later time. In this case, Ensign concedes that there's no current service that it intends to provide, and these conditions will be revisited within 5 years, and at that point, presumably the formal protocols will be in place and we'll have more information. Lastly, on the topic of joint responsibility, there's nothing improper with holding the joint applicants jointly responsible for complying with the Commission's conditions. This is especially important because the curtailment condition involves the joint effort of the generation resource and the larger load customer. As I said before, rather than dictate the exact process, we're leaving it for the applicants to figure out how the process goes from the generation resources queasy to ultimately load reduction. And as stated, Goodnight has control over the breaker, which should be sufficient operational control to ensure that curtailment happens within 30 minutes. I mean, there are other ways in which it could occur without their involvement, so that's enough to be able to ensure that curtailment occurs, and since their queasy will be notified, that makes sense. So with that, I'm happy to answer any questions. Thank you for your time.
Back to Ensign to close. You'll have 4 minutes and 23 seconds.
Thank you. I think maybe I'll address the easy issue first, which is this communication and responsibility issue. Having looked at all of the arguments on this, Ensign is prepared as a condition of this proceeding for you all to require it to have a QSE of its own to receive communications. I think that is a more direct path than going through Goodnight's QSE. It allows us to partition responsibility, and it seems to solve all of these issues. So we would suggest adding a condition that we have to maintain a QSE relationship to receive any instructions from ERCOT, and I think it solves that issue. On the remainder of the issues, I mean, I think you have a pretty squarely presented policy question of, are these conditions going to be fact-based, based on the specific impacts of the proposals, or is it going to be a one-size-fits-all? You've heard Mr. Bigby say that ERCOT's intent is to have standardized requirements for these proceedings. Ms. Mago said the same thing in her testimony, that ERCOT intends to propose a standard curtailment duration ramp period of 30 minutes for all net metering arrangements. Essentially their vision is to do this for every one of these proceedings, regardless of the facts. Our view is that that's not what the statute requires, and the facts don't support this. I do want to address the efficiency of these types of arrangements. So the goal of this arrangement was not to get priority access to this existing generator in emergency conditions. It was to leverage an existing interconnection. That gives speed to market. It minimizes the need for additional transmission, and it's an efficient structure as long as it doesn't have adverse reliability impacts or cost impacts on other customers. And that's what the record reflects. So we are also very concerned about setting a precedent here that these efficient co-location strategies that should reduce the need for additional transmission build out are going to be subject to such onerous conditions that they're not commercially viable. And so we are again asking for reasonable modifications to these conditions such that we can comply with them. Thank you, and I'll be happy to answer any questions.
And last, Goodnight to close, 3 minutes, 21.
Thank you. And I'll be, excuse me. I think that, not yet. Okay, apologies. I'll be quick here. I just wanted to echo one last thing Katie said, because I think it is incredibly important. ERCOT's position that the only way to ensure that a load will not create a reliability issue is to curtail the load is a rational policy position. But it's a speculative justification for imposing conditions on this net metering arrangement. It goes beyond maintaining reliability, and it seeks to add an additional layer of protection to the system, a free ancillary service, if you will, without having identified any reliability concerns associated with this particular arrangement. That does not align with the statute. There is no reliability nexus here. The condition must address a demonstrated reliability need. If the same reliability outcome can be achieved without the condition, it does not meet the statutory standard. The condition cannot be based on precaution or preference. And with that, I'll close. Thank you. Happy to answer any questions.
Yes, that concludes oral argument.
Commissioners, questions?
I think I only have about two, and I appreciate all of you being here, especially since this is a case of first impression. I appreciate oral arguments as well. This one actually is, I think, is for Mr. Bigby. Could you walk me through the policy and I think also the legal justification of including having Goodnight responsible with regard to demand response programs?
Yeah, and that one I think is maybe the most debatable point we have on this issue. I think the reason we proposed a condition like we did was because we wanted to give the commission the flexibility to say, all of you are involved in proposing this arrangement. That is the design of the statute. You are joint applicants. You're involved in this net metering arrangement. You've agreed to net the generation and load together. Clearly, you're involved together in this arrangement and have contemplated something contractually to work together and in this joint undertaking. And so I think quite arguably it makes sense to suggest that however you have arranged this mechanism, that you should you should ensure collectively that this load does not interfere with ERCOT's existing, or the PUC's and ERCOT's existing demand response products. So whatever those arrangements may be, you all figure that out amongst yourselves to ensure that this load doesn't register and participate in these demand response programs. So I think that would be the best way to insulate against that risk. If the commission were to isolate that determination to just the load, I don't think that's a grave concern for us, but I think that's ultimately the commission's discretion. I do think it's critical that because of our current system limitations, that we ensure that the generator, the resource entity, PGC entity, is involved on the curtailment side. And that's just because today that's all we can do. We don't have a queasy arrangement that Kate and Juliana spoke about. We don't have that existing today. We would need time to implement that. We are actually envisioning that sort of framework to have direct communication with customers. We're developing that and are hoping to propose that very soon. But that's going to take some time to actually implement in our systems, because you have to associate the queasy with some entity in our systems, and that isn't set up today. So that's why we need the queasy for the generator to receive those communications and communicate those to the load under this sort of interim framework today. But on the demand response side, I think there's maybe some more flexibility. We wanted to give the commission the room by proposing that in the condition to adopt that as a finding because of the joint undertaking, but we don't strongly oppose that the commission, were to limit that, to the customer. Now, staff may have a different perspective on that, of course.
Staff agrees.
Okay, thanks, Floyd. I think that's all I have for right now.
I do have I'm going back and forth, so it's more to kind of debate and ask. But Ms. Coleman, you noted that having standardization curtailment as a one-size-fits-all is not what you saw the statute necessarily specifying, right? My question is, part of me thinks it would be beneficial to have that as something ERCOT could present so that everyone understands what, if they do get into these net metering cases, what it would look like to have. But then I do still think that it is something that, once that is looked at, could still be modified by ERCOT specific for each case. And I want to see what the commissioners are thinking in their response, because I think it is helpful to have standardization, but I also still, in my opinion, thought it would be something that could still be changed by ERCOT if it needed to be further or more, I guess, conservative on that part.
Let me just ask clarity. So when you're saying that it gives a little bit of reasonable certainty and regulatory certainty to have a standard set of conditions for each net metering arrangement, subject to, though, additional tweaks based on the net metering arrangement.
Right. That's kind of how I've been looking at them, and then realized that might not be obviously how everyone else is thinking.
Yeah, I mean, I would say as I've thought about this and going back to last session, I think as you've framed it, I'm fine with them offering up a standard set. I don't think that the law was intended for us to adopt a standard set of requirements on every project.
Right.
So, again, I'm not going to tell ERCOT how they should, what conditions they should put on them. If they believe that there's a certain set that should apply universally, I think that's fine. I don't think we're required to adopt the same requirements for every project.
Yeah, that was my thinking of it. It could be out there and helpful, but not necessarily what was always the case.
But I think what I heard in this particular case from ERCOT was that they believe in order to maintain system reliability and also in terms of the operational integrity management of the system and being able to manage risk, that these are the conditions that they are recommending for this particular project. So I know we're speaking of them in terms of standardization, but I think for this particular project, what they have proposed is what they see, at least from an operational standpoint, of what's needed to maintain the reliability of the system and to manage that risk. I did have one other.
Can I ask a clarifying question then to Nathan on that? So I saw you shake your head when Commissioner Jackson said that these are the conditions you believe need to be in place in order to ensure reliability for this specific project. Is that right?
That's accurate, and that assumes, right, that the statutory purpose here was to hold sort of load harmless from the load addition. If this were a greenfield load and gen addition, there is no prior right we would have to that generation, and we just take whatever the net impact of that arrangement is on the system, right, subject to the interconnection studies that would apply to both of those. But because the statutory presumption appears to be to ensure that load gets the reliability benefit of that generation, if push comes to shove on the grid, then we believe that is the design. And so to ensure that we achieve that purpose, we need a curtailment condition, and something that's narrowly tailored to limit that to emergencies helps us ensure that reliability purpose is served.
Just to jump in, then my question is, what legal standard or burden of proof were you looking at throughout the conditions?
Well, I think burden is a complicated question because the applicants, presumably have the burden of proof in this case. ERCOT, of course, has proposed the conditions, and so it's an interesting posture. But I think I view this as being a regulatory issue, right? The commission has discretion to regulate through contested case just as much as it does through a rulemaking. And this is a case, I think, where you need the former course of action where you are establishing policy through a contested case because it's important to have that transparency and a non-discriminatory path for potentially dozens of arrangements that could be going down this path. As far as the burden of proof, I mean, I'm not sure exactly how to look at that because of the very unique posture of this proceeding, but we believe the commission ultimately has, wide discretion under the statute to determine exactly what conditions to adopt, and of course you have our proposal in front of you.
Yeah, I think I was just more getting at the necessary for reliability purposes, that if you thought the standards that were imposed through the conditions is the baseline of what is actually necessary.
So, I mean, and that's our argument for limiting this to EEA conditions. We've had 4 EEAs in the last 10 years, right? This isn't something that happens every day, at least up to this point, right? It hasn't been super common. Transmission emergencies are also not super common. These are edge cases, right, that come up on the grid, and extreme cases where you need someone to do something, right? You need to take heavy-handed action to make sure the grid stays intact, as you all know that very well. And so this is really just kind of limiting our authority to interfere with this arrangement to that very edge case. This is not something we're going to be doing every day. This is something that is going to be narrowly tailored to these exigent circumstances to honor the legislature's intent, which we believe was to say, in the case where that's going to threaten reliability, make sure you have that generation available to serve incumbent load. And we'll defer to the commission's interpretation of the statute, but that was our inference about what the legislature was trying to get at, to ensure that when you add these loads, it doesn't put the rest of the grid in a worse position than they were before.
I appreciate that. Thank you.
Yeah, go ahead.
Ask a new guy question. And under those circumstances of an EEA, is the standard currently a 30-minute curtailment?
So right now, transmission operators have 30 minutes to shed SCADA controlled load. And I think it's a fair point that essentially any load on the system is subject to being disconnected at 30 minutes or less, depending on what the TO, the transmission operator, determines as part of their load shed scheme. When ERCOT directs load shed, we assign each TO a percentage of that based on this load shed table that was mentioned earlier, and they've got 30 minutes to get the SCADA control load, which is the vast majority of the load, off of the system. So that's already an expectation, essentially, that every load on the system has to bake into their paradigm. That's just kind of an implicit assumption on the grid. So I think 30 minutes kind of aligns with that fundamental notion as well.
Is there an allowance or an appreciation beyond 30 minutes right now?
So there is a narrow circumstance where non-SCADA control load is subject to load shed in 1 hour. But that's not, majority of the load is SCADA control on the system, and that is our expectation. That amount is growing because it's important to have, it's better to have SCADA control load on the grid. It's just that the operating guide and the protocols allow for that distinction.
If I could respond to a couple of things Mr. Bigby has said, while I appreciate how he's describing that ERCOT intends to implement this, the conditions do not reflect what Mr. Bigby is describing. There is nothing tying it to an energy emergency alert. It's at ERCOT's discretion when they anticipate an emergency condition, which it's not tied to a specific PRC level. It's not approaching load shed. And that's the concern, is that this could be done early and often. And I appreciate the assurance that that's not ERCOT's intent, but they could do that under the proposed order. And that's really what most of our proposed modifications to the conditions are aimed at doing, is providing a little more certainty around how this is going to be used, and providing us some ability to prepare for a 30-minute deployment. As I mentioned, Ensign can deploy the load and reduce it to zero within 30 minutes, but doing that without causing damage requires an advance notice. When we get to firm load shed, all bets are off. Everybody can be curtailed. I mean, that's a different scenario. We're talking about a preferential early deployment of these particular loads.
Can I ask, is there certainty at a particular time certain?
Well, what we've proposed is when we hit a certain reserve level that indicates that you're approaching emergency conditions, that I think we agree. It's 3,000 megawatts of physical responsive capability is a standard that's been used in other contexts to identify when there's a reliability risk on the system. And that was our suggestion for when this could be used, because we are very concerned that, you know, if Mr. Bigby said earlier, there's a benefit to turning these loads off. Certainly there is. There's always a reliability benefit to reducing load on the system, right? But that's not the standard. It is what is necessary to maintain system reliability. So just because ERCOT identifies a benefit to doing this doesn't mean that it's justified under the statute. And we're trying to modify the conditions to really tailor it to what is necessary based on the facts here.
I think part of the challenge we have is that, you know, these are nuances. These are new loads, big loads that are coming into the system. And so what we're trying to do is to accommodate that and, quite frankly, facilitate that, but to make sure that we are preserving the reliability of the system and the ability of the incumbents to continue to operate. And so there are a lot of unknowns that are associated. You do the study, but I think, as you mentioned earlier, there are, you know, operational conditions that are not necessarily identified in the study that could happen. And so I think what we're really trying to do here is to put in place a mechanism by which we can preserve the integrity and the reliability of the system, and that the new entrants know what the game plan is and the rules are when they enter, and they can work around that, have their backup generation ready to go, and be able to, so we can accommodate both, because we very much want the loads to come, but we want to put in place things that that allow us, particularly at this stage in the game, to be able to account for things that maybe we didn't necessarily identify through the study process. So, I'm really leaning towards, what ERCOT is proposing in terms of their criteria.
Commissioners, real quick, I know we've been going for about 90 minutes. I know the court reporter typically needs a little bit of a break. So if it's okay with everybody, I have maybe a handful of questions to ask. If we can take maybe a 15-minute recess to give the court reporter a break and then come back and finish up this case, if that works for everybody. All right, with that then, we will stand in recess until 11:15. The commission will reconvene its open meeting at 11:18 a.m. Commissioners, did y'all have any other questions for any of the parties?
I have one for Goodnight, maybe. When you build out infrastructure and you're looking at, I guess, what level of insight do you have into the operations of load? Can you see that they reduce? And if you can you see what they're reducing for?
I would need to phone a friend on this one.
Oh, okay. You have a phone?
I have a virtual phone.
Hi, Bianca from Serena, the owner of Goodnight. On the generation side, we do not have any insight on how the load is operated. So we do not see how the energy flows once it gets through with the load side.
Okay. So no, and Floyd, you mentioned, well, they have a breaker, they can just switch it, but you wouldn't know you need to switch it or not, right? Because you have no insight into what's happened, or is that interpreting it wrong?
Well, my understanding, again, I don't know the specific operations, I thought generally in a net metering operation, the generator would know what the flow is at the point of interconnection, and presumably they know what their units are outputting, so they presumably would have some insight into what the load was doing. But as to your question, taking that at face value that they don't actually see the flow at the breaker, they wouldn't necessarily know whether the breaker would be, what the flow is when they disconnected. I mean, regardless of it, you could still presumably disconnect it and...
Just flip it no matter what?
Yeah, either it's already curtailed, and in which case nothing would happen, or it is curtailed and then, well, I assume a design breaker you wouldn't see anything that's,
Okay.
One more question.
Can I just compliment here? Our QSC can see the flow between the two, the gen and the load.
Yeah, go ahead.
Oh, sorry. So the QSC can see the flow between the gen and the load, so they are able to see this flux between the two. Our side on the generation, we are not aware of how the load is being operated inside their side. And when it comes to the breaker, we would receive an order to shut it down.
Okay.
So there is a communication that would send this information.
Okay, thank you.
Nathan, did you have something?
Could I briefly respond to that? I just want to point out that, the queasy for the generation resources, has a duty to give us accurate telemetry at the point of interconnection for whatever's happening inside that network. So they have to know what's happening, inside their network. And the idea that the generation resource and its queasy don't have that visibility of what the load is doing is, we find to be very implausible. They're absolutely going to have to know what that flow is inside their own network to be able to give us that accurate telemetry. And so setting aside, who operates the breakers, how those are controlled, there absolutely should be visibility of what that load is doing and its real-time consumption at all times.
The last question I have is for Floyd. Going back to the rule and the statute, Floyd, because I want to say it was you guys that mentioned in the filings as well, the rule and the timelines with regard to filing when we're coming up to that 5-year deadline. Could an applicant, if conditions were imposed in the arrangement, could a gen or load file something prior to the deadline specified in the rule, acknowledging something that is not working well? And if you're not the person to answer it,
No,
happy to, okay.
No, thank you for the out, but I think I can answer. It's, well, there's the existing rule that just went into effect.
Yes, sir.
Wednesday, and under that, I believe it prohibits filing before 3 years.
Okay.
As I read it, but absent that, I suppose you could ask for good cause to be excused from the rule and then file to modify at any time. I mean, if there were good cause, I believe the commission would be able to grant an exception.
Okay,
So
okay. Is there
if
any,
something not working, yeah.
know if there's any, Dave, on the net metering arrangement rule? Okay. Sorry.
This is Dave. I'm not aware of that.
Okay, thank you.
That's David
David
Gordon
Gordon.
with commission staff.
Yeah, and he's probably mad at me now.
So Nathan, I want to go back to something just real quick, because you said, I think the term used was a threat to reliability. And so from ERCOT's perspective, all of these projects will have some impact to reliability. Is that fair?
All the projects are going to have an impact on the amount of load on the system, and more load on the system increases the risk of a reliability issue driven by a capacity shortage, or in a transmission case, an overload that might be driven by a load addition.
So whether it's less than 1% of the time or 50% of the time, it's the same from y'all's perspective.
You think the remedy could be the same? I mean, I think it's, what is a reliability risk? When does something become a reliability risk is a question for discussion, right? But under the statute, I think it gives the commission discretion to decide exactly what that threshold is, for sure. From our perspective, it makes good sense that if you project a PRC level, we talked about PRC before, 3,000, whatever. Our proposal is 2,500 if we anticipate dropping below 2,500 for more than 30 minutes, that's the EEA1 trigger, then we would take these measures. Among other things that we will need to do under SB6 for 50% backup gen, curtailment among vehicles and other instruments that we have, we're going to need to take those measures to avoid that EEA condition. That is what our interpretation, our understanding is, to avoid the emergency that would pose that threat to load.
So you use the term anticipation. Can you put some parameters around that? I've been on calls at 5 a.m. sometimes where we're expecting PRC to be really low and we never get there. Is that the type, could we leave a call like that on a cold winter day? There's an anticipation in the morning that we're going to be below it, and ERCOT just issues a bunch of notices that curtailment may be necessary?
So I think that really highlights the risk that we have here, and the more loads that we have coming to the grid, the more loads that are co-locating, that are in a curtailment bucket of some sort, the more that we're going to have to look at conditions further in advance. And if we are seeing a condition some hours out, it is possible that we may have to take action earlier on. Now, under our proposal, we've got a 30-minute curtailment trigger. So if a small number of net metering loads show up, we can wait until we get closer to that 30-minute trigger and say, are the conditions going to resolve themselves? Is the weather going to get better? That sort of thing. But if we've got 50 gigawatts of load and we're seeing a 20 gigawatt exceedance, we're going to have to take action before we get to the 30 minutes, in part because of what Nithika testified, which is we can only really accommodate 3,200 megawatts in any one tranche because of the risk of simultaneous deployment to frequency. And so the bigger the shortfall that we're projecting hours in advance, the earlier we're going to have to start taking action with these loads. And so there are possibilities where you may have to take some action some hours out in order to begin taking action hours out to address that risk. If that risk resolves based on the first few steps that are taken, or the weather gets better, whatever the conditions are, then we wouldn't have to curtail anymore. But there are eventualities where we might have to curtail further in advance because of the number of loads involved and the amount of the exceedance that we're seeing.
Okay. Katie, on Ensign's alternative proposal, help me work through that really quickly. So you're requesting a 30-minute curtailment with a 60-minute notice, at least 60 minutes. So in a situation like I just talked through with Nathan, would we potentially be setting up a framework where ERCOT knows, let's say we do all of these uniquely and we accommodate kind of everyone's unique needs, 60-minute notice, 120-minute, whatever it is. Could we be setting up a framework where they say, okay, the longest period that the PUC approved is 2 hours. So 2 hours out, they just give everyone the same notice that you could be curtailed within the next 2 hours, meeting every requirement, and then at some point in there, just give the 30 minutes. Like, you know what I mean?
Yes, the deployment itself can be done within 30 minutes. It's the pre-positioning that requires advance notice, and I think that would be a workable solution. I mean, I assume there will be a limit to how much notice somebody can reasonably request, right? So like if somebody came in and they said, I need 5 hours, I need 24 hours, I think it would be within your discretion to say that doesn't meet the need, of the statute and provide a shorter notice period. But we're asking for a 1 hour notice to pre-position, and then we can comply with a 30-minute deployment. So in your example, if you're having meetings at 5 a.m. about what's going to happen today, at some point, as circumstances evolve throughout that morning, issue a notice to all the loads that are in this bucket and say, hey, by the way, you may be deployed, and then they can do what they need to do to be prepared if that happens. That's really all we're asking for.
So a potential outcome, though, of that is a lot more notices could be sent.
To those loads, yes.
Correct.
Yes, and I'll say it actually, I think we acknowledged this in either testimony or briefing. It could involve some false starts, right? Like we're going to get a notice, you may have to curtail, we do some things, and as you noted, as happens sometimes, those conditions don't develop, and we could be told, never mind, you're not going to have to curtail. And we understand that the longer the notice is, the more likely there will be kind of these false starts. But it's the amount of time that we need to assess what's going on at the site and make sure that we can bring it down in a way that's not causing like loss of data, equipment damage, those types of things.
So then your client is okay with that trade-off?
Yes.
Okay. Nathan, one thing I think about, and I talk about up here often when we're talking about programs, is ease of administration. From an administrative standpoint, having different requirements for time to get notice and things like that, how difficult is that for ERCOT to manage as we are potentially heading into an emergency event?
So I think that's a really good question, and I think that they're certainly having multiple tranches that are defined by each of the loads based on their druthers about how long they need to curtail is really a non-starter from our perspective. We cannot design systems around an infinite number of curtailment triggers. But even adding more default buckets creates complexity as well. For 2 hours, 4 hours, whatever buckets might be defined, those would be problematic. From our perspective, having a 30-minute obligation that we can then put into multiple tranches that can be deployed earlier if necessary, ahead of an anticipated EEA condition or during an EEA condition, is critical. And so, I think that's a really good point, that we really want to limit the buckets because of the complexity for the control room. We're dealing with humans in the control room who have to manage the grid. And so, we've got to keep things fairly simple under existing triggers so that we can put these in buckets that they can deal with and not create unnecessary complexity. That's a big issue that we haven't really talked about today, but I think that's a really important point, that we've got to keep this cut and dried for administration purposes. And if I may point out, if I may briefly address the point about notice, I think we agree that giving folks notice of a potential deployment would be helpful and is something we would want to do. I think that's something we're talking about building into our curtailment paradigm that we're actively working on right now. We agree. We want folks to have notice that there may be an issue coming up. The critical thing, though, is that There are a lot of situations we can imagine, especially with the changing grid we have today, with more storage coming to the grid, the higher possibility of running out of state of charge, and with the solar ramp that we all know about and face, every day, that creates operational complexity and creates a higher risk that we may hit a 3,000 PRC trigger a few minutes before we hit an EEA condition. The more storage you're adding to the grid, the higher that risk becomes. And so as the grid is evolving, right, establishing that sort of firm PRC trigger as a condition for us to be able to direct curtailment, to start the 30-minute clock, from our perspective, is not consistent with reliability. We need to be able to start that curtailment whenever we project that we're going to have a deficiency, right? And that deficiency right now is defined at 2,500 PRC under our proposal, right? That's still narrowly tailored to align with an emergency condition. But from our perspective, it needs to be based on an anticipation. When do we actually think that's going to happen? And are we close enough to where we actually need to start deploying these loads in order to alleviate that condition, right? We're not going to be deploying them days in advance because of this issue. We're going to wait till we absolutely need to do that, as we do with our other tools. We don't want to interfere with the normal operation of the market if we can avoid doing that, right? It also creates a requirement to invoke the price adder, which we don't want to do unnecessarily. The price adder, sorry. And so we want to avoid that, but requiring notice in a fast-moving event, that may not be possible, I guess, is the bottom line, in a fast-moving event for us to provide notice. And if that is a non-negotiable for any deployment, that, in our opinion, creates a reliability risk, at least that we would not be able to get these loads out of the way before we have to hit firm load shed. And that is the risk that we're dealing with here. And there are a lot of events you can imagine where you have some unit trips, you have batteries running out, and you need to get these big loads that are consuming power on the grid out of the way to protect the residential and small commercial consumers on the grid. And you can't do that because they have a longer trigger.
I agree with that. I mean, then couldn't the condition be tailored for a situation like that, where the standard is you would give some kind of notice, but obviously if operational conditions are deteriorating that quickly, you've got to do whatever you have to do, right? I mean, as opposed to it always being one without notice for those instances where you may not have time.
I think we are open to the idea of being required to provide notice when that is feasible. And we think that's a good idea to do that. But we don't want that to be an absolute or a guarantee 100% in all cases, because that may not be possible. And with a lot of large load additions, that may become even more complicated because you may have more fast-moving events.
Right, and again, that provides an incentive most likely for you all to issue more notices because of that. But I think what we're hearing is in that trade-off, at least in this case, the applicant is good with that trade-off.
That's what it sounds like. And yeah, I mean, there is a risk of notice fatigue. That's just, I think, potentially inherent in this process. Some notice is better than no notice, perhaps, when notice is feasible. And so I think we're open to that approach. I want to be clear that ERCOT's position is that it would be difficult for us to guarantee that could be provided in all cases.
Sure. Katie, I think I have one last question for you. So you noted that this is a wind resource. Would the discussion we're having here be different if it was a thermal dispatchable unit?
It would, because the statute has different requirements for dispatchable versus intermittent. And I'm glad you asked that question, because I earlier didn't get a chance to respond to Mr. Bigby's statement that treating co-location involving wind differently from a dispatchable generator would be discriminatory. That discriminatory treatment is required by statute. There is a specific provision in the bill that says if it's a dispatchable generator, that much dispatchable generation has to be available in anticipation of EEA. So essentially what's being proposed is that requirement that was targeting dispatchable resources would be applied under ERCOT's proposal to all intermittent resources and their co-located tenants, regardless of the facts. And that's the exact concern, is we don't believe that the facts really justify any curtailment obligation here, I mean, based on the actual record, but we're willing to agree to something that is reasonable.
But there is no prohibition against the commission adopting that same standard for a non-dispatchable resource.
There is no prohibition if it is, in your view, necessary to maintain system reliability, yes.
Commissioners, other questions? So I came here hoping I would be comfortable making a decision. Normally we wait at least one open meeting after we hear oral arguments so we can think about it. Obviously, this process was set up to try to get answers quickly. As I sit here right now, I think I have probably as many policy questions as I came in with that I think I'm going to need to talk through with my staff and OPDM through the issues that have been presented. So I know we've posted this for next Thursday. My ask would be that we take a week and bring this back to an open meeting on the 23rd to make a decision to go over all of this, if that's okay with everybody.
Yeah, I like it.
Okay, thanks y'all. Appreciate
Thank
all
you.
the input. All right, that'll conclude the contested case portion of the agenda. We'll move now to rules and projects. First is, I believe, item number 17. That is project number 58391, implementation of Senate Bill 740, system improvement charge.
Good morning, Chairman and Commissioners. David Gordon for Commission staff.
David, can you pull that a little closer? Thank you.
This is David Gordon for Commission staff. Thank you. Good morning. Yes, this is our proposed recommended adoption order for the system improvement charge rule revision with associated forms. This implements legislation from the 89th session in Senate Bill 740 and will set up a streamlined process for the submission of SIC applications. This went through a fair amount of changes from proposal for publication, and also is different from what we had preceding the rule change and the new statute. I'm happy to talk about any of those items with you all, subject to your discretion.
Commissioners, would it be helpful to get an overview of the changes? Do you have questions for David?
No questions.
Questions?
Just a comment.
Yeah.
In terms of, this was really a heavy lift. And, the system improvement charge was one of our legislative priorities. And, I think what we've kind of struggled with over time is getting the form and the standards and the information that we need to be able to make the decision. And so I'm very appreciative of the work, and particularly the detail that you provided in doing the forms, and recognizing that this was both it's going to benefit not only the utilities, but also I feel like the ratepayers. So I just wanted to say thank you for this very, comprehensive look, and in my mind, this extraordinary work package.
Thank you, Commissioner Jackson. I want to note that there were, I think, 6 divisions within our agency and over 20 PUC staff members who worked on this rule. I also want to thank the commenters and the stakeholders who provided their input. And there's one special person who really devoted a lot of hours and thought and critical thinking to getting this right. And of course, that's me. So you're very welcome. MacArthur was the one who pulled us over the line. So.
Good job.
Mac, thank you for supporting David with his heavy lift.
No, but thank you very much, Commissioner Jackson. I do appreciate those words, and thanks.
Commissioners, anything else?
No.
Yep.
All right, with that, I'll entertain a motion to approve the proposal for adoption.
So moved.
I second.
I have a motion and a second. All those in favor say aye.
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 Opposed? Motion prevails. Next on the agenda is item number 19. That is project 59603, commission approval to file comments on FCC NPRM 26-8, opt-out state reforms. Good morning, Jay.
Good morning, Chairman, Commissioners, Jay Stone, Commission staff. I seek your approval to file the comments for the notice of proposed rulemaking that the FCC put out. Comments are due. Can you hear me now?
Yes.
Can you hear me? This is a notice of proposed rulemaking that the FCC puts out. They put it out every number of years. The main portion of the proposed rulemaking is for Texas to keep, as long as I know it wasn't me.
I think Gordon did it.
That we're trying to keep our opt-out status from the national database that the FCC does. In 2012, the FCC came out with an order that separated out the federal lifeline discount requirements from the state lifeline discount requirements. And so it wouldn't be so cumbersome for Texans to apply for the two discounts, one with the federal government or the USAC, Universal Service Administrative Company, and then one with us, the PUC. We opted out of the NLAD process. Every number of years, they bring it up. They look for process improvements, not only with the opt-out states, but all the states in the way USAC runs the program. This NPRM is asking the same question: should Oregon and Texas keep their opt-out status? So we feel we do a great job. I think our filing shows the record that we do in all the audits that are done by the FCC and USAC. And so with that, we seek your approval to make these filing comments. Reply comments are due June 2nd, so we may be back at I think it's the May 29th, seeking the same approval if we're going to file reply comments.
Thank you for that layout, Jay. So there are two opt-out states currently?
Yes, it was 3. California was removed from the program on things that they did internally in California, some laws that they passed. So the FCC removed them because they wouldn't be able to file the requirements of the FCC in the Lifeline program. So the FCC quickly removed them from the program.
Commissioners, I'm in favor of this. I think the process we have laid out in Texas works for Texas and for those in the Lifeline program, and I'm in favor of approving these comments.
I would agree.
I am as well.
Same.
All right, I'll entertain a motion to approve the proposed comments and authorize filing of those comments in FCC NPRM 26-8.
So moved.
Second.
I have a motion and a second. All those in favor say aye.
Aye.
Opposed? Motion prevails.
Thank you.
Thank you, Jay. That'll bring us to item 23, project number 59142, review of ERCOT's interconnection process for large loads. And before we get ERCOT up, we have someone that has asked to do public comment on this rule.
Yes, if Shannon Caraway could come up.
Is she here? Okay. I'll take a short intermission while Mike goes and tries to locate. Okay, well, if they come back into the room before we finish this item, we'll hear from them. All right, so ERCOT? Shannon? Perfect. So if you could state your name, you'll have 3 minutes.
Yes, sir. Is the microphone on?
Yes, sir.
I'm Shannon Caraway with the Yolick Development Partners, and I want to start out by thanking...
I can pull it closer.
Shannon Caraway with the Yolick Development Partners. I want to start out by thanking both the commissioners and ERCOT staff for the important work that y'all do to provide us a reliable system. Yesterday, we filed comments, joint comments with Google and Lancium that really had one principal request, that in the upcoming batch zero process under Pier 145, that recognize TSP developed large load projects or RPG projects, that it recognized those as base load in that auction or in that batch zero process. And the reason for selecting or for recommending that is it was consistent with the interim large load process, and we recommend that that be done consistent with an April 1 submittal, which is compliant with the PUC 58-480 rule that RPG projects submitted by up through that date use the existing process that was in place versus the higher standard that 58-480 implemented. To help illustrate why we think this is so important is, and this wasn't in our written comments, we've got a project that we started developing in 2022. We had a signed interconnect agreement with our TSP in November of 2024. So pre-legislative session, pre-Senate Bill 6, pre-Picker 115, pre-Picker 145. Our TSP has faithfully worked extremely hard moving that project through the RPG process that the interim large load set out, as well as Picker 115. They started it, they ran both of these in parallel. And then 3 days after they notified us that we had met the Picker or the Planning Guide 9.4 requirements, we gave notice to proceed and said notify ERCOT that we want to implement, 9.5. We've then moved forward and we've got EPC contracts, we've got customer contracts, we're starting construction on a project that has to be online in just 18 months. And we find out last Friday that ERCOT is recognizing this project is not meeting 9.5 until 3/24, 20 days after the 3/4 date, this retroactive date they set in Picker 145. So you can imagine the stress that causes when you've got existing contracts that have met all these rules, and from a reliability perspective, there is no demonstrated reliability need to not be able to move those forward. And so we're narrowly requesting those two things: RPG projects, because we were in an RPG project, and if ERCOT that were submitted by 4/1, and if ERCOT feels they need a retroactive date to automatically make things get rescreened, it not be before 4/1, so that the TSPs would have had approximately 4 weeks to be compliant with it, because the current 3/4 gave TSPs 0 days to be compliant. And that I conclude.
Thank you, sir. Jeff, if you want to do your layout, and then we'll have staff lay out their memo.
Good morning, Commissioners. Jeff Billow with ERCOT.
So I'm going to start my update with a recap on what has happened in our activities to move to a batch study process for large load interconnections. And then I'm going to spend the bulk of my time going through some issues that have come up in the stakeholder discussions on PGR 145. Since the last open meeting, ERCOT filed comments on April 4th. We have endeavored to, as stakeholders are giving us feedback, we've endeavored to try to address that feedback and made a number of language improvements based on those comments on April 4th. We also held what is likely for batch 0, our last stakeholder workshop on April 9th. And covered various aspects of batch 0 as well as draft language for CLR and then also some concepts for BYOG to be included in batch 0. And so with that workshop, we are transitioning now to the voting bodies. And so this week we held our first batch 0 discussions with the ROS and PRS. And we'll continue that, having those discussions almost on a weekly basis with the subcommittees. And I'll go through the schedule on our March to June 1. Also, what's not in my update, but I'm happy to report that yesterday we sent a list of each large load interconnection project for the TSPs, sent that list to the TSPs. And noted with respect to the draft PGR 145 language where each of those large load interconnection projects stand as ERCOT sees it. We expect that TSPs will provide us feedback if they see any disagreements, but it's a way for us to, because we don't have that direct relationship today with the customers, it's a way for us to be able to communicate to the TSPs who can communicate that status to the customers. We also, on April 9th, posted some draft language for incorporating the CLRs, which CLRs are dispatchable load. So we had a number of customers that have expressed interest in being able to connect to the grid and not having to wait for transmission upgrades to get their full megawatts, but being able to, as grid conditions allow, being able to use the megawatts, and if grid conditions are tight, locally transmission-wise, then being able to back down. And so we move forward with this concept of what we're calling a provisional controllable load resource. The difference between this provisional controllable load resource and a regular CLR is really kind of three things. So one is how we would treat them in a batch study. So in this example that I have in the lower right, if they, in year 1, they want 150 megawatts, but the grid can only support 100 megawatts, they can connect that full 150 megawatts, but the SCED would be able to dispatch them down. So we would allocate them that full 150 megawatts in year 1 with that understanding that they may have to at times back down to 100 megawatts. So there's that allocation aspect in batch 0. There's also certain registration requirements where they would need to tell us ahead of time that they intend to be a PCLR and follow that construct. And then finally, there's certain provisions that ensure reliability in real time, the ability for SCED to be able to dispatch these when needed to solve transmission constraints. And so I'm happy to report that this morning we actually formally posted the language for the PCLR concept. And I would say when we presented the concept, we got a lot of positive feedback from stakeholders, and so I was encouraged by that. And then before I get into the issues, just a reminder on the timeline of where we're at. So we've had 7 workshops. I mentioned we have moved to the stakeholder committees and presented at PRS and ROS this week. Next week, both PRS and ROS have special meetings to take up the batch 0 revision request. PRS is focused on the NPRR, ROS on the PGR, but we'll also discuss the NPRR. And then we are shooting for votes from both of those bodies the first week of May, which would get us on a path to get to TAC and have a TAC vote on either the 19th or the 20th, which gets us to the June 1 board for board approval. So I mentioned that as we have been engaging with stakeholders, we have been working with them to try to address the comments, but there are several comments and topics that have come up where we wanted to bring those to the Commission's attention. Commission feedback may be helpful on these issues, so I'm going to walk through each of these over the next several slides. The first issue is really similar to, or really the same issue as what I came and talked to you about at the last open meeting, which is this issue of the reliability studies and making sure that those reliability studies are valid. Of course, every large load that comes and expresses an interest to connect to the system, we need to do a reliability analysis to understand what is the reliability impact of this load connecting to the ERCOT grid. The challenge that we've had with the current process, as well as with prior processes, the legacy processes, is that the volume that we are seeing, those processes were not designed to handle the volume. And so what we have experienced is, if I have, as an example, load A that expresses an interest to connect to the system, we will study that load A. The TSPs are performing those studies, but then I may have load B that comes in shortly after that, and neither load A or load B are included in each other's studies. And so when one of them completes the process and wasn't included in the other studies, then that other one needs to go back and perform a restudy on their impact studies. And so really the key issue here is, how do we think about that validation of those studies going into batch zero? The options, I'm going to take them out of order. Option B, which is what ERCOT has proposed in Figure 145, is that on March 4th, ERCOT did a look back, and we assessed and every study for projects that we knew had completed the process on March 4th, we looked at those and said all of those studies are valid. Going forward, as the volume of these studies are increasing coming in, we have proposed that we will do a check on those studies as they come in. Since that March 4th date, we have had a little over a dozen additional projects that have completed the process. We are right now reviewing each of those studies. And I can tell you some of those we will inform the TSPs that those studies do not need to be redone, that we have validated those studies. There will be others that we will tell them that other projects have come in and completed that process before they did, and they will need to go back and redo those studies. If the TSPs are able to complete that redo of that study, that restudy before July 10th, then those projects can still qualify to get into batch zero as baseload. Now, of course, we have received a lot of feedback, and I think you just heard Mr. Caraway express that additional check that we are doing, that is creating uncertainty for the developers. And so there have been several proposals on how to address that. One of the proposals that stakeholders have favored is option A, which is all studies that come in by July 10th. Everyone who completes the process by July 10th, that ERCOT should automatically consider those studies as valid. I think our reliability concern with that would be that if we do that and don't have that ability to perform that check to make sure that study is still valid, then we could be allowing more loads to connect in an area than what the transmission system can reliably support. And so ERCOT is not in favor of that, but I do understand that uncertainty that's creating in the market. And then option C is a variation of that. Option A, which would be for projects that, so we would maintain what we're doing in option B, except for projects that are included as the justification for the need of a transmission project that is approved through the regional planning group process. That alternative would be to allow those studies to be considered valid. And I think that is more limiting than the option A. However, that still presents a potential risk to the system that we may be allowing more loads than what have been studied that we know we can reliably serve in an area. So I'm going to, I provided some additional slides for context. I'm going to skip through those for the sake of time, but I'm happy to go back and talk to those as needed. So the next issue I wanted to talk about is financial commitment and site control. So if you think about going into batch zero, there are sort of three filters, if you will, for projects that are in the current process to go through those filters to get into batch zero. So that first is the study. We need to check to make sure that those loads have a valid study. The second and the third are financial commitment and site control. When staff laid out 5841, their draft proposal, there was this idea that the financial commitment and the site control requirements set a higher bar than what exists in the current process. So the current process does not require site control, and the financial commitment lever that is in there is it's a little bit open-ended. And some of the comments that we have gotten from stakeholders, this goes back to January when we interviewed individual stakeholders, was that the individual TSPs have different interpretations of what that financial commitment, what those requirements are, should be. And so when we laid out Figure 145, we attempted to put in this higher bar of financial commitment. And we came and talked to you at a previous open meeting about the different options around that. But the option that we chose to go with was to do to replicate what is in the draft PFP that was posted on, I believe it was March 12th. We have replicated those into Figure 145. And so that sets a higher bar compared to what the current rules are. There have been several commenters, both at ERCOT and also in the 5841, that have expressed this idea that the projects, the large load projects that have gone through the current process, they have, to the extent that they have met those requirements, that we should respect those requirements. And so as an example, if a large load came in on April 17th and met the current requirements, which are laid out in Planning Guide sections 9.4 and 9.5, they would say that we should not require additional financial security above that going into batch zero, that we should respect what was in place at the time on April 17th when they met those requirements. So that is a proposal that stakeholders have put forward. And then in option C is really sort of the blank piece of paper. Obviously, the commission can decide on what y'all think is most appropriate going into batch zero, which may not be what we have proposed. Copying 5841 may not be the respecting the existing requirements. It's really whatever y'all think is appropriate. So just a way to acknowledge that we're open to that. And again, on this issue, I would say ERCOT, as long as we have that study validity check, we don't have a strong preference on this item. And then sort of related to that is this comments that we have gotten regarding the 2026 RTP. So 2026 RTP eligibility for loads to be included in that was laid out in 58480 in the 2026 compliance plan. And so this is another standard that is, again, higher than the existing bar because it requires site control. And we've had a number of loads that have argued that if I have been included in the 2026 RTP, then I should be included as base load in batch zero. I think that with the numbers that we've posted this week on the load forecast coming out of that process for the 2026 RTP, I think that likely leads to unreasonable results in the in batch zero, and so ERCOT would not be in favor of this adopting this criteria for entry into batch zero.
Jeff, just real quick on that, I agree with you.
Okay. So. Thank you. And then last two issues really are around this idea of projects that have what we're calling near-term energization, which we have defined as any projects that would energize between now and the end of 2027. And there's a number of layers to this, but comments that we received from, I'll say, some developers was that if there are projects that the developers are currently telling us are expected to be in service between net now and, again, near term, which we're defining as end of 27, that those developers should be able to demonstrate that there is some development activity, and there are different ways to look at that development activity, but there are some that they ought to be able to demonstrate that there's some development activity going on for those sites. And if they are not, then one of the comments is, ERCOT, you should administratively push their development date, their energization date out, because if you include them, then you are taking up transmission capacity for loads that don't have a viable path to energize in that time frame. And so that first idea, kind of what is option A there, is to administratively set their energization date as 2028. And then the next layer to that is comments that we've received that, and if I am a developer and I can prove to you, ERCOT, that I do have development activity, and I am, again, I can prove that, then that should be equivalent in a higher standard than the financial commitment requirements that that you've laid out in Paragraph 145. So we really think of that as sort of an alternative to the financial commitment requirements, because they can demonstrate that they have, for example, purchased their long lead time circuit breakers and transformers. They have construction activity going on at the site, and so I think their argument there is that from a ratepayer protection perspective, that ratepayers should feel comfortable that there is work going on at that site, and they will be able to show up and start consuming energy. And then there was other sets of comments that we've heard where essentially it is this idea that checking for this development activity, that it may be hard to objectively check that, and so there are some developers that are saying, ERCOT, you really should not be checking that because you don't have a good objective way of doing that. I think ERCOT's perspective on this is really, I think that feedback that we heard that we should be checking this, that was useful, and I think we would like to adopt some form of this into Paragraph 145. And then the last issue I have for you is around if we do put this check in for that development activity, what level of due diligence is appropriate for that? So you think of this as sort of a spectrum where the kind of on the low end, the developer would be required to do an attestation that they have met whatever development milestones we set, and then sort of in the middle would be that they would be required to have a third party come in and verify, to so to speak, audit that they have met these requirements. And then the highest level would be that ERCOT would maybe hire in some outside expertise to come in, and the developers would then be required to hand in their homework and show us that they've purchased their equipment and show us that they've have this development activity, and then we would have an expertise to come in and audit that. And there's probably a range of options in the middle there, but I will stop there and happy to answer any questions.
Commissioners, questions for Jeff before we start? Hear from staff and then go through all of these issues. I think, Jeff, one thing of note, just really quickly, I think it's worth noting on slide 4, your timeline. The amount of work that has been done in such a short amount of time is staggering. And I don't know, I'm not in tune with how other jurisdictions are doing this, but I think everyone involved, again, deserves a ton of credit for getting this process going so quickly. The amount of good work that's been done, again, it's just staggering. It's a compliment to you, to our staff, to the folks at ERCOT that work on this, all the stakeholders that have provided input since we decided to not move forward with a good cause exception in February. It's just amazing the amount of work that's been done. So thank you to your team for everything that you've done on this.
Yeah, thank you. Yeah, I'm not quite as humble as Mr. Gordon, but thank you anyways.
David,
wants this one
if you
too.
start taking credit for everything, people start looking at you when things go poorly, trust me. So one thing you said just kind of caught my attention. You said you sent out a list of where projects are to the TSPs, and you imagine there would be some back and forth to reconcile that. Ultimately, if there's a disagreement about where a project is, how does that get fully reconciled?
Yeah, so we would work with the TSPs to understand where that. So the process today is the TSPs need to inform ERCOT when they have met certain milestones, when the projects have met certain milestones, and so we can check our records if they think that they have sent that notification to ERCOT, then we can check our records. But it's back and forth discussion with the TSPs.
One thing on that real quick, I think for those large loads that are out there wondering where they are, you just heard that your TSP has that information. So you can look to them to get that clarification, correct?
That's
and
right.
This is
Yes.
just where you are right now. It does not mean that could not change.
Correct.
Depending on how this goes forth,
Yes.
correct?
That's correct.
Thank you.
Barksdale, just for kind of run of show, does it make more sense, because I want your input on some of these open questions from the ERCOT presentation, to go through those first, or would you prefer we lay out your staff memo and then go through both together? Do you have a preference?
I think it's really whatever makes most sense for your conversation, Chairman.
Okay, why don't we go ahead and have you lay out the staff memo?
Okay. Thank you, Chairman. So staff last weekend filed a memo after having the opportunity to review ERCOT's deck that Jeff just walked through. And apologies to everybody for the late timing of it, but we were trying to provide you with real-time information, because as I indicated to you all, about a month ago, there was going to be a point in time in this process where the rulemaking and the development of PGR 145 were going to have to start to diverge, and PGR 145 was really going to have to get focused in on what Batch 0 does, and the rulemaking in Project 58481 really needs to start thinking about what's going to happen for the future. And as I mentioned a month ago, those processes were very well aligned up until now, precisely because we wanted to develop the concepts that were necessary for any kind of batch, so that while Batch 0 might be different than Batch 1 in terms of some of the specific nuances, conceptually they're part of the same holistic paradigm. And I think we've done that very well, and it's a testament to the ERCOT staff and to our staff and to the stakeholders that they were willing to endeavor that pathway with us, because we knew that there was going to be this moment in time. And so we filed this memo to help refine some of the ideas that are apparent in Jeff's deck here, where they're seeking some additional input from the commission. And also because some of the concepts that we put into the PFP in the interconnection standards rule, we were looking for markers for project maturity, so that we could identify objective, independent, transparent criteria to be able to pick those real projects, get them through the transmission planning process in a way that folks understood how it worked, and have that process yield reasonable, rational outcomes. And the draft rule, I will take all credit and blame for the sledgehammerness of that draft rule. We tried to use financial commitment as the major marker for project maturity. And through the process of the batch workshops at ERCOT, I heard loud and clear that that wasn't really refined enough. We needed something more nuanced to be able to pick apart which projects should be eligible as baseload into Batch 0. And so I think the memo that we filed last weekend really tries to address that. Similarly, you just heard Jeff talk about another kind of proxy for project development as the expected energization date. I think it's a good idea. It's a worthwhile consideration, but it's perhaps maybe not quite refined or nuanced enough still. It's a smaller sledgehammer than what we proposed in the draft rule, but still I think it's kind of knocking some projects around in a way that doesn't quite result in the rational outcomes that we might anticipate. And so our memo is really designed to offer you some ideas about how to refine concepts around project maturity. And the table at the end of our memo, has those specific ideas, and happy to talk about any one of those that you would like. But before we get into specific conversations and questions about the table, I do want to clarify just a couple of things. First, on the table, the last row talks about the number of days to sign an interconnection agreement after batch 0 results are produced. I confused things by having that row in this table because this table is really about the entry requirements that we are recommending to you for a project to get into batch 0, not about what should happen after batch 0 is run, what the developer has to do in the time period between the end of the batch 0 run and whatever should come next. That row is really supposed to address the concerns that we heard loud and clear in the workshop process, that the 30 days that we proposed in our draft rule for the developer to go back to their interconnecting TSP to amend an interconnection agreement or whatever kind of contract that they might have right now, the 30 days in the rule was not sufficient time to be able to get that done. And so I apologize for that confusion that I caused there. The second thing that I wanted to clarify is also in this table, we talk about refundability of some of the financial commitments. And again, the table is really, it's meant to be viewed as the entry criteria. So when we talk about refundability, we're not talking about the commitment that needs to be made to get into batch 0 necessarily from a refundability standpoint. We're talking, the refundability is really about what's going to happen after the batch 0 run occurs. And I wanted to put it in there because it's been such a tremendous source of debate at ERCOT and here as well, that I thought it was important for staff to signal to the industry and to provide you all with our perspective about how we should be thinking about the refundability of those financial commitments. But again, I think I confused it by putting it in a table that's about entry criteria, whereas it probably should have been a little bit more clearly fleshed out in the memo, in the body of the memo. So I think I'll stop there. Hopefully that helps lay out the conversation, and I'm happy to answer any questions. And we also have Jesse Horn here, who is the true mastermind of everything that we're doing.
Thank you for that layout, Barstow. Jesse, thanks for all the work on the rule. Again, I'll say the same thing to you that I said to Jeff. As far as my understanding of all of this, I don't know where I'd be without the hours that you and I have spent together over the last 5 months talking through all of this. So I appreciate all the time you've put into getting all of us up to speed on all of these issues, because this is really important what we're doing right now.
I appreciate that. Thank you.
So commissioners, maybe we start there with the staff, what's included in the staff memo. We can go through our thoughts on the different issues. One issue that's not really present in there is how this is all going to interact with net metering arrangements. And so I think we need to also have a discussion about that. Barstow and I have talked about that at length as well, some ideas for how to make that work. But maybe we go through the staff memo and the chart and then circle back to study validity and some of the other issues, just to make sure Jeff is clear on our perspective on that. Does that work for everyone? Okay. So Barstow, I think for you and I, the first issue that we talked about was actually on page 3 of the memo, the minimum capacity allocation being set at 100 megawatts. I think from my discussions with most of the data centers, they've indicated a threshold of probably around 200. So I think, in areas where we can give you kind of precise direction, I think we should. In an area like this, I think you're going to end up seeing more directional input around I think, at least for me personally, commissioners, I think we need a minimum allocation. I think that makes a lot of sense. I don't know exactly what that number needs to be. But wherever we set it, we then also have to figure out what that means for projects that need less than that minimum. So whether that is you get the lesser of your request or say 100 or 200 megawatts, whatever the minimum threshold is, there's a way to get there. But I don't know that I'm comfortable right now, given kind of the full array of responses I've gotten on what the right number is, to say what that number needs to be, but I think we do need one. I think somewhere north of 100, 200, 250 feels right to me based on the conversations I've had. But would be interested to hear if you all have received any different feedback on that issue.
No, the feedback's just been, don't forget the smaller number down. So wording on that would be interesting.
Clearly, your staff knows how to math.
We know many things, but I'm not sure it's how to math.
I think a minimum capacity allocation's a good idea, and it needs to be part of the conversation as well, just for certainty and for a good roadmap, especially with some of the financial security requirements or discussions that we're having.
Yeah, I think the minimum threshold, I think you mentioned, the magnitude is about what I've been hearing, something north of the 200 megawatts, and then also making sure that we account for, the lesser of the threshold or what the ask is.
I agree with all those comments as well. And in particular, take a look as well at financial commitments as we get
So then next, on the chart, the commitment for direct costs, kayak paid. You and I discussed, we heard from some that kayak isn't always paid for those direct costs. Sometimes it's security or another instrument. So we had a discussion around, can we expand that category for showing payment for direct costs? What are your all's thoughts on that idea?
Yeah, I think it's a great amendment to how we're thinking about it. And really, I think what we were trying to express here is that there needs to be some demonstration of commitment against the direct costs as a marker for project maturity. And if it's kayak payment, or if it's security against direct costs, or another financial instrument that the stakeholders can share with us, I think we're open to those conversations. And like with all of the conversation that you may be having here, directional input is extraordinarily valuable, and we can take concepts and principles and refine them into more specifics in the remaining stakeholder conversations. And if we need to, we can come back and talk with you individually as those processes are going on.
Yeah, I think that's a good plan. I would also say, in our discussions, I'm also trusting of you and staff to know what we're trying to solve for there and make sure we're hitting the mark. Commissioners don't want to be overly restrictive in what we're adopting and then find out that, certain projects are in certain areas of the state that, they do it differently than, say, a kayak payment. And so we've now caused a situation where those projects have no ability to get into batch zero, even if they meet the other markers.
I would agree with that. I think it'd be prudent to take into account and consideration what's already being occurred, what is already occurring within the state.
I agree. And certainly an application of credit towards those kinds of costs that they're otherwise taking a look at, to be fair, across the board. Again, I completely agree, Mr. Chairman.
And just a question for clarification purposes. For the financial security, it's cumulative. It's not going to duplicate continuously. Is that correct? Or have we hit on that?
Yeah, so I think the draft rule, and I'm going to look to Jesse to punch me, or maybe I'll just actually turn them. Do you want to answer that?
I was looking forward to you punching him.
Jesse Horn for Commission staff. So separate and apart from batch zero, the way that the rule is drafted in 58481, the intent there is that the $50,000 per megawatt as part of the intermediate agreement would apply going forward at the interconnection agreement phase. So if you're moving forward at that point, it becomes 100% non-refundable. It's not that you would be required to post an additional $50,000 per megawatt at the interconnection agreement phase. So, sorry.
Go ahead.
Well, I see that I didn't explain it clearly enough, so I was going to try to take another stab at it.
Take another stab.
So the first $50,000 per megawatt at the intermediate agreement phase, that's it, you're done. The difference in what we were trying to capture with the second restatement of that at the interconnection agreement phase is that at that point it becomes 100% non-refundable. And so it is just the one. There's also the difference between security and the actual payment, and that's the other piece that we're trying to capture. So it's initially security, one time done. It becomes a payment at the interconnection agreement phase.
Thank you for that clarification. That's what I was trying to suggest earlier.
And Commissioner, I think there's an opportunity for us to, in the rulemaking, thinking about the future, in the rulemaking to make these concepts a little bit more clear. I think also for batch 0, using the rulemaking to specify what the financial commitments and the refundability of those financial commitments are during what ERCOT has called the developer commitment period, so that what we're proposing to be 60-day window that starts after the batch 0 run is done. We can use the rulemaking to specify which commitments are required, which additional commitments are required, and what percentage of those are non-refundable. I think the timing of the potential adoption of the rulemaking later in August or perhaps early September allows us to set those standards and have them in place in time for batch 0, the completion of batch 0, which I think is March?
January.
January,
Yes.
okay, so that should, hopefully we can continue to have public conversations so we can set industry expectation, use the rulemaking to plant the flags, and then everything is known several months in advance of the completion of the batch 0 run.
I have full faith in you.
Thank you, ma'am.
Which is good, it gives the information people need to make that decision.
That's the intent.
All right, so next down, security for system upgrades. We talked about, financial commitment. Maybe, Barstow, it'd be helpful to talk through the thought process behind the percent that's refundable in the 2 baseload categories and the studied category, and then talk through projects that have already put up significant security for development and how that'll end up getting netted potentially against any security that's put up.
Okay. So I think the first concept here is that we're proposing that if the developer knows already what the cost is for the system upgrades, that should be the measurement. And they should post financial security against that. Or perhaps there are other similar kinds of instruments that we should be considering, but just kind of in layperson terms, financial security against the known cost. If the known cost is 0, if you know that there are no system upgrades, then you're done. There's no need for an additional financial security, because what we're trying to do with this is protect ratepayers against projects that require transmission upgrades on the system, and then that project fails to materialize. And then the ratepayers are stuck holding the bag on that upgrade. Alternatively, if the project does not know the cost of those upgrades, then we've used this proxy amount of $50,000 per megawatt as a placeholder, which we think is a reasonable amount of money to assure that ratepayers will be protected in the event that the project fails to materialize. The reason, maybe I'll stop there before I talk about the difference in the refundability in these 2 baseload projects and just make sure that I'm being clear.
Commissioners, questions?
I think the second part of that is actually just where I needed more clarity.
Okay, great. So the difference between the 100% refundable amount in this kind of middle baseload column and the 50% non-refundable amount in the intermediate column for baseload is to acknowledge the fact that projects that are more well-developed or more advanced in their own process have likely spent a significant amount of dollars, are more likely to come online than those projects that are earlier in their development phase. And because they are more likely to come online, I think staff's position here is the risk of ratepayers left holding the bag on transmission upgrades, system-wide upgrades, is lower. And therefore, there should be some acknowledgement in this process that the risk is lower, and therefore the more advanced projects should have a lower bar here. The earlier phase projects, these intermediate projects, feel more speculative. They feel like the developers are still working through their business plans or are still looking for tenants to take over their sites, or that they might be floating 3 or 4 different sites for one potential project. This feels like a bigger risk to ratepayers. And so we're suggesting that if they don't know the system upgrade costs, that they should have some sort of financial security against those potential upgrade costs. And coming out of the batch process, there should be a non-refundable amount to that, so that if they walk away, anything that the ratepayers are left holding is covered. Now, we've proposed 50%. I think we started out at 80% earlier, and I think we're certainly open for different interpretations on what the right risk cost benefit analysis is. That's a weird thing to say, but hopefully you understand what I'm saying. We have not talked as a staff about how to do true-ups against actual costs, and it's a thing that we have recognized as a need to talk about, but I'm sitting here right now, I don't have a clear answer for you on how to address it yet.
Yeah, and I think that's okay. I think just the recognition that we have to reconcile that makes a lot of sense. As far as the percentages, I'm good with them. We've heard some feedback for the studied loads that should be 100% refundable. As we've talked about these, especially for batch 0, where we're trying to funnel projects that are closer to becoming energized. I think there's a risk there if we make it wholly refundable that it does not act as a gating issue. That is not a real threshold. And so while I understand that developers don't like the idea that you may get 20% of what you've had to put up may not be refundable even if your project doesn't move forward. Hopefully that is a disincentive from putting projects in that really have no real vision, line of sight on coming to fruition on any realistic timeline. And so that's the reason I'm comfortable with that. I appreciate the pivot from 80-20 non-refundable to 80-20 refundable on that as well. I think that strikes the right balance in that category. Commissioners, thoughts?
I'm just looking at the statute and it's security provided under subsection H1 must be refunded in whole or in part after the security is applied. So in regards to refundability, how is any percentage supposed to be held back if it's supposed to be refunded in whole or in part after you subtract security from it? Can you talk me through that thinking?
Yeah, go ahead.
Yeah, so what Jesse Horn for Commission staff. Commissioner, what we're relying on there is the in part. So going back to the purpose of SB 6 in that we are trying to support business development by making sure that the outcome of this process is a load forecast that we can have confidence in, and at the same time trying to make sure that ratepayers are not stuck paying the bill for stranded assets. And so on the statute, what we're saying is that to the extent that the statute permits the dollar per megawatt security specifically to be refunded in whole or in part, we think it should be a certain threshold, a certain percentage. We don't think it should be in whole. And I say that knowing that there's different layers and tiers that we've just talked through, so it's hard to talk in absolutes, but that was the interpretation on that.
That's helpful.
And I think just for clarity, this is also, I think, where you guys were talking about, right, with project maturity in the slide about looking at development agreements, long lead contracts, et cetera. So these two types of ideas would be tied together then.
Jesse Horn for Commission staff. I'm sorry, Commissioner, could you restate that?
Well, I want to make sure when Jeff was mentioning the project maturity slide, which I think, I think it was alternative requirement slide, page 12, yeah. When he was mentioning this as like a sliding scale with regard to financial commitments or financial security, is this the financial security portion that was being discussed or thought of? Or was it the site control, the commitment for direct costs? And if we don't know, that's okay too.
Yeah.
So, Commissioner, I think first we're going to look a little bit more closely at slide 12 and make sure that we're tracking. Second, I think Jeff, in his remarks, talked about project development and, ordering certain items like circuit breakers or transformers and things like that. So the long lead time equipment, I think, is a great marker for project maturity. Those specific items would be more about the direct cost of the project. And so if it's the circuit breaker on the project side of the fence, then that would be an indicator to us that they believe that project is real, it's coming to fruition, they're willing to invest their capital in order to move forward. If it's equipment on the utility side of the fence, then that's a marker that the load has told the utility, yes, we are real, go ahead and start ordering this stuff.
Okay.
The system upgrades are going to be more about the downstream impacts on the transmission system as a whole. And so, I don't know that we're necessarily thinking about long lead time equipment, for example, as being directly related to the system-wide impacts that we're trying to safeguard against. Jesse, is there anything else that you wanted to add on that?
No, I was going to say that's right, and I apologize for the confusion. I just wanted to be sure that I was precisely answering your question, and Bark still did that.
While we're on what development activity means and talking site control, I think it would maybe be something that we could look at, and I want to get maybe thoughts back from staff and from ERCOT, but, staff has said they support additional evidence of project maturity. I think it would maybe make sense to look at other types of evidence, if it's zoning agreements that have been entered into or participation in certain types of programs, even, you're in a net metering arrangement or some other program that you're getting benefit from the state from, if that has to put them in a certain order of the studies. I don't know how that would work, but is that something we can think about?
We certainly can think about it, and we did think about it for inclusion in this table, and I ultimately decided that to get a zoning designation, it does represent some level of project advancement, but in terms of the evidence that I think we want to see for advanced staged projects, I'm not sure that it is of the same evidentiary value, for lack of a better way of saying it, as some of these other things which represent real dollars, real commitment, real project maturity. I think you can go to a city council and get a zoning designation pretty early on in the project development cycle. And I don't want to minimize the work that goes into it or the cost to the project to go get it. But I think it's an order of magnitude less than I'm going to go ahead and order my transformers.
Okay. I think there are some components that, certain other steps that maybe would be pretty strong that we don't want to close the door on those. So I might talk with you offline.
Very happy to hear your thoughts. Yeah. And Chairman, if you don't mind, I forgot to mention this when I was talking just generally about this row on our table. Part of the reason why I think we don't have a specific recommendation on how to handle the refundability or how to do the true up is because this also implicates a project that we're not really posted to talk about, but I'll just reference the 4CP evaluation and rulemaking, and I would anticipate that there is going to be the Venn diagram between what we're doing here, what we're doing in the interconnection standards rule, and the 4CP rule will represent the suite of effort that this agency is doing to address the underlying principles and requirements of Senate Bill 6, and taken all together, that will be the way that we handle things like the true up on system-wide upgrades and ratepayer protection in a really fundamental and I think ground-shifting way.
And Commissioners, just real quick, so we're almost up on another hour and a half. So what I would say is let's finish our discussion through this chart, take another short recess for the court reporter, circle back to Jeff's presentation, make sure we talk through all the issues that he would like guidance on, and then work our way through the end of the agenda after that. Does that work for everybody? Okay.
Yes, sir.
So I know, Barksdale, you said just real quick, and Commissioner Yalman, thanks for bringing up again the net metering arrangements. Before we get to that real quick, I know the last row here you talked about shouldn't really be on the chart, but since it is, appreciate the change, the recognition from 30 to 60. What I have heard is 60 is really kind of the low end, so I think that's good for a low end threshold, but probably worth hearing from different folks about if it needs to be even a little higher than that. I think 60 in my mind makes sense, but again, I don't want to sit here today and just cut off projects because for one reason or another they might need 75 days.
I absolutely understand that, and I think right now this is really trying to represent a balancing act between the speed with which the industry is really demanding progress. If we build in additional time, which is a very reasonable position to take, that just means that the results of the transmission planning process are going to be longer. You might want to talk with ERCOT about its thoughts and make sure that there's not anything else that I'm not thinking about here, but I think it's really that balancing act.
Yeah, no, and I agree with that. It's it's obviously reasonable to extend that timeline out, but that does, every day is a day later for when we put forth that transmission plan.
Okay. All right, so, as we've been working through this, net metering arrangements have kind of been there, but we haven't really been front and center. I know you and I have talked about it. Jeff, we've also talked about how to accommodate net metering arrangements, how they'll be handled in this batch process. So, in reading through comments and talking to folks, one of the ideas that was put forth that I want to discuss is the idea, using kind of your March 4th timeline, that a net metering arrangement that provides an application under the Senate Bill 6 requirements that was done by that date would be modeled as in the base case, in the base load, but then of course subject to any type of conditions that would need to be put on it based on that inclusion in the base load case. So given that as kind of a backdrop, what are your thoughts?
Yeah, I think that's reasonable, particularly if we have that ability to put the conditions on. And I think limiting it to the ones that came in before March 4th, that's a smaller universe of projects, and so I think that ERCOT could live with that. I think the one thing that I would want to go back and think about is what is the load level that would be considered as that base load. So as an example, if a project was 500 megawatts, but we saw problems at 200 megawatts, would we want that project to come in as 200 megawatts or at 500, and maybe this is in early years, maybe it's, 2028. We want it to come in at 200 or 500. We could obviously put conditions on, but then if you're having to declare transmission emergency, that may not be reasonable. So we may want to look at the studies, but I'd want to take that back and talk about that a little bit more internally. But conceptually, I think ERCOT is okay with that.
Yeah, Chairman, I think, as I continue to go back to our core principles of trying to identify real projects that can enter into batch zero as a base load, thinking about the category of projects that have proposed net metering arrangements, I think these are kind of meeting that standard of projects that are likely to come online within a near term. And I think the process for your review under the net metering arrangement rule provides, kind of checks that third box in our objectives of a repeatable process that results in a rational outcome, because you can impose conditions on that net metering arrangement should ERCOT's analysis of the transmission security reveal additional concerns that you might think are appropriate to address through that order. The only thing that I don't see immediately in kind of checking my three boxes of the principles is how are we protecting ratepayers against a project that might fall through. And again, maybe the likelihood or probability of one of those projects falling through is low, but perhaps there still is some risk to it. And so maybe it would be appropriate to also suggest that some financial commitment against those system-wide upgrades that perhaps is fully refundable is the appropriate thing to do coming out.
I think that's a good suggestion. In a lot of these, I assume those costs will be rather de minimis, if not zero. But yeah, I think you're right. I mean, with an eye towards protecting the ratepayer, I think something like that makes a lot of sense. Commissioners, thoughts on this issue? Again, not one that was, I'd say over the last 6 months has been kind of primary, but something that we have to figure out how to accommodate through this process. And so just that's one idea. If there are others, happy to entertain them.
Again, many of these projects are already in the hopper. They're already making progress. And I think, as you pointed out, they're ones that can come online in the near term. So I think this is a good suggestion.
I'll just say in my short time here, I've been incredibly impressed with what I've seen from staff and also ERCOT too on this effort. So just echoing your earlier comments, Mr. Chairman, very impressive. As one who's been involved with many states and infrastructure around the country and all, it's rare that you see this kind of a thoughtful process and in this kind of a short time frame. So hats off to you. And of course, Dave as well too in the back. So.
Commissioners, any other thoughts or questions on the staff memo before we take a short recess and pivot back to ERCOT?
I had just one small question from Barksdale, and it refers back to slide 13. The approaches to verifying development activity for near-term projects. And I guess in some of my conversations with staff, you're potentially recommending option A, which would be requiring developers to submit formal attestation of the development activity. I think option A is a good outcome, but was wondering if we should also consider maybe raising the bar to something that was more than just the attestation and maybe include satellite imagery that could further document the construction process. And that would provide evidence and data of actual construction happening. And was just wondering if this is something maybe that you could brainstorm with staff about.
We absolutely can talk about it, Commissioner. We recognize that by recommending the developer attestation that we're leaving a little bit of risk on the table, and it's done with full knowledge that it's a trade-off with speed. And we could certainly seek other pieces of evidence to try to bolster the attestations and try to reduce that risk, and happy to talk with our staff, of course, and ERCOT staff, and maybe some of the developers to see if they've got some additional ideas that perhaps wouldn't slow down this attestation process too much, but maybe the satellite imagery is the perfect thing. Maybe there's another idea out there that we can develop to just say, it's not just my word, but it's also my word plus something else. Maybe it's a photo.
Or a zoning agreement.
Or a zoning agreement. Ma'am, that could well be. Again, it's going to, so then we get a zoning agreement. Who's going to review it? Who's going to say, yes, this zoning agreement actually is associated with XYZ? So it's just, I think there are lots of options that we can take to minimize risk, and the more robust of a process we have, the slower we're going to have to go, and that is the trade-off that we have to make. And we'll look to you for your guidance on how to do that.
Understood. Commissioner, no shortage of great ideas. So, any other questions? All right, so why don't we stand in recess and reconvene at 1:05. All right, the open meeting will reconvene at 1:08 p.m. So Jeff, you had a number of slides in there with recommendations. I think maybe an easy way to do this is, Barksdale, from staff's perspective, are you all supportive of their recommendations? Are there certain recommendations in there that you believe need to be modified, or we should go a different way?
Thanks, Chairman. Yeah, I think staff supports all of ERCOT's specific recommendations, and for those areas for which they did not provide a recommendation, our memo was intended to fill in those gaps.
Commissioners, given that, any discussion on any open items, or are we good with the ERCOT recommendations?
I'm good.
Okay. I think we're good. Yes, go.
Chairman, if I can go back to the minimum load allocation issue.
Yes.
So I think my understanding, and correct me if I'm not understanding this correctly, is that if we have a minimum allocation, for example, of 200 megawatts, if the study showed that we could only reliably accommodate, say, 50 megawatts at that location, then that load would just not be allocated megawatts in the batch zero study.
That's correct. That's my understanding.
Okay.
Yes.
All right. Thank you.
Yes, sir. Commissioners, any other issue under this item before we move on?
I think so.
Not for me.
Okay. Jeff, thank you again for all the time and for being here. Great amount of work.
All right. Thank you. Thank you.
All right, that'll bring us then to item number 24. That's project number 58777, Triennial Reliability Assessment for the ERCOT region under section 25.508. Afternoon, Werner.
So, good morning, Chairman, Commissioners. I'm Werner Roth on behalf of Commission staff. So, to break this out at the start, going to briefly touch on the different recommendations staff offered in their memo, offer a couple of updates to those that have come to light since I did briefings for all of your offices, and then summarize some of the additional recommendations we had in the memo about timeline. So, just to start off, Commission staff largely supports what ERCOT filed in their final recommendations. And to that end, our memo doesn't touch on every single recommendation that was made in the ERCOT list of recommendations. We focus on areas that fall into one of three categories. We either disagree with ERCOT's recommendation and we provide an alternative. We agree with ERCOT's recommendation as a baseline, but recommend a sensitivity to go along with that. Or we recommend that while their recommendation is fine for this year, additional work should be done prior to the 2029 reliability assessment to refine how that recommendation was reached. And so staff provided recommendations on updating several items, including the update of the cost into entry, the resource mix that was used, fuel price assumptions, the load forecast, the weighting of weather years, the inclusion of a zonal analysis in the assessment, outage assumptions for extreme weather conditions, and the magnitude criterion for the reliability standard. I do want to note on two of those, we're going to request that no decision or direction be made today. First, on the cost of new entry, staff will be planning to file an additional memo ahead of the May 7th open meeting. We've had conversations and we are going to update the reference technology. In the memo, I think we recommended the small frame combustion turbine. That was at the time when we filed that, there was the discussion of, okay, what kind of technology is going to be readily available or potentially available ahead of 2029? As we are now looking at, okay, what technology we're trying to incent long-term. We're trying to make the cone as a long-term market signal. We're going to go back to the larger frame CT that we've used historically. Tends to be more economic, more efficient long-term, but that's just one that isn't readily available to be procured by 2029. So we're going to update our recommendation on that. And additionally, because after we filed our recommendation, ERCOT also filed the 2026 the load forecast. They asked for conversations with commission staff around that, and so we're wanting to have our discussions with them on that, and then come back to the May 7th open meeting to potentially lay out a plan for how to address that and potential changes to the timeline that would create. And then, lastly, I wanted to touch on the two other items that we had on the in our memo. First, we would recommend that the commission direct ERCOT to publish all non-confidential inputs and outputs from the assessment. They were pretty good about doing this during the creation of the reliability standard rule. We felt that having as much information out there as possible for the interested parties to digest as we make decisions would be prudent. And additionally, for the second item, we're going to recommend that the commission provide clear direction for ERCOT how we're going to proceed once the assessment has been run. One of the requirements in the rule is that ERCOT, once they've run the assessment, they would publish the results over at the commission, and if we're deficient in any of the years, they would provide market design recommendations on how to address that. We're recommending that we be very clear this time that we plan to bifurcate that process. So when they run their assessment and the final results are available, they would publish the final results over here. They would that would allow time for interested parties in the commission to digest those results. We could potentially see a special ERCOT meeting or through TAC or some workshop over there to review the results of the assessment. And then after a sufficient amount of time, then if there was any deficiencies identified in the assessment, then they would file the market design options over here, and then we can have a discussion around those. And so that would extend the timeline for this additional time, but we believe that this provides all interested parties and the commission more time to make sure we fully digest everything that comes out of the assessment.
Yeah, I think that's right. I think we want that time for feedback. So yeah, both those recommendations are, I think, are good. Commissioners, questions for Werner on this?
For what you just said, what added, like, timeline-wise, what do you think that looks like adding additional time to it to be back?
So for the split, I mean, we're anticipating that would potentially be an additional month on the back end of this, and
okay.
We can, if we get the sense that the commission's fine with that approach, I already committed to including some kind of a timeline that could accommodate if we need to adjust for the load forecast, including a timeline in our May 7th our memo ahead of the May 7th open meeting. I would incorporate this as well into that.
Commissioners, thoughts or comments on their recommendations?
So on, taking a look at the RTP, the thought was to, initially we were going to take those results and utilize those, but now we're looking at an alternative, and that would give enough time for ERCOT and others to participate, correct?
Yes, that is correct. So for the low forecast piece, I need to dive into this a little bit more. I know that we just recently approved the rule around the load forecast methodology and assumptions, and there's a section in there that talks about what needs to go into any modifications to that load forecast, and that would require additional time to go through that whole process.
Everybody supportive of their recommendations? Barksdale, do you have something?
I guess I just want to highlight what Werner just said, that the new Rule 25.370, there's a subsection in there that you all approved that lays out a process to adjust the load forecast. And it contemplates having staff and ERCOT staff work together to come up with a proposal that would then provide some opportunity for stakeholder feedback. I don't want to quote specific timelines, but I think there's a 30-day minimum in there for stakeholder feedback unless you choose to take up the issue more quickly than that. So just to be clear, the delay to the reliability standard assessment, assuming we use the process in 25-370, which I think is probably very appropriate here, the delay there is probably longer than a month. It's probably 45, 60, 70-ish days, depending on open meeting schedules and things of that nature.
Yeah, and I think, what we learned from, and we'll have ERCOT up to talk about the load forecast. What we learned from last year is we have to be inclusive in that conversation about how we look to refine the numbers that came in. I think that was that was the big takeaway from a year ago, and so I think getting as comprehensive and as much input as we can into the right way to do this makes the most sense. And if that causes a delay, I think that's just something we have to deal with. Got everything you need? I think we're supportive.
I think so. Thank you.
All right.
Thank you, Chairman.
Then we'll have ERCOT come up under this item, talk about the load forecast numbers.
Good afternoon, Chairman, Commissioners. Chad Sealy with ERCOT.
Nithika Mago with ERCOT.
So you've already kind of highlighted the filing that we made on Wednesday around the long-term load forecast that goes out to 2032. This is based upon the new process under the RTP compliance plan that was part of the rulemaking process. So this is the first time we've kind of used this new process where we issued an RFI to the utilities, and then the utilities had to respond by April 1st. So what we filed on Wednesday was our preliminary results from that RFI. We have gone through some due diligence with the utilities, particularly on the medium-sized loads, which is the 25 up to 75 megawatts. But ultimately, the large loads, the 75 megawatts and greater, is a very defined process now under the RTP compliance plan. So it really is how the utilities interact with those customers and meet the kind of standards that was in the RTP compliance plan. And as you've seen in the slides that we filed on Wednesday, we have a significantly high load forecast as a result of that process. That process means we take our base economic forecast, which has some other features to it, and then we layer on top of it the medium-sized loads that are really based on officer letters from the utilities, and then the RFI response consistent with the RTP plan for those large loads, 75 megawatts and greater. And so that's what you see reflected in the load forecast for 2026 through 2032. As has already been discussed, even for 2029, that is a very high load forecast that could have a lot of implications in our studies that we do, and not only the reliability assessment, but the resource adequacy studies, the transmission planning studies, because we're required to use this load forecast going forward. The next kind of impact would be the CDR that comes out around the third week of May, which we would be required to use this type of load forecast in the CDR unless we don't move forward with the process that Barksdale already highlighted and seek some type of adjustment in front of the commission. So I'll stop there and see if Nithika wants to add anything else on the specifics of the forecast.
I don't know that I have many things to add. I think Chad did a great job of covering it. We are here to answer questions if you have specific.
So again, commissioners, I think it's clear we need to engage in the process to look at ways to refine this number to something that's more usable. I think the process that's in rule makes a lot of sense to allow for that engagement with stakeholders. But happy to hear your thoughts on the filing. If you have any questions for ERCOT at this point.
I don't have any questions about what you filed. You mentioned, and I agree, ERCOT's long-term load forecast is the backbone of so much of what we do here and so much of reliability planning and of our reliability assessment. And so since every decision really that we make as commissioners and everybody else makes really depends on the accuracy of the forecast, and what we do as far as building or not building will be affected by that, I think I would support using the rule that we did lay out to go back and make adjustments to it.
Yeah, I'm in supportive of using the rule that we laid out in order to go in and make an adjustment to the load forecast. And I think, as you mentioned earlier, the expectation would be to engage ERCOT staff and the TDUs in that process.
Reasonable. Hey, Chad, do you need anything else on this?
No, Chairman, we'll coordinate with Barksdale and his team, and as Chairman Jackson indicated, Commissioner Jackson indicated, work with the utilities as well in the preliminary discussions on thoughts that they may have as far as adjustment ideas. The rule kind of lays out two paths. We can use a historical realization approach that we used last year when we sought adjustment, or some type of new type of methodology. So we'll start those discussions and see where we go.
Perfect. Thank you for that. Thank you for the filing.
All right. Thank you.
Next on the agenda is item number 25. That's project number 58481, rulemaking to implement large load interconnection standards under PURA 37.056. And I believe someone signed up for public comment on this item. I would also note, before we hear public comment, in this docket, we did receive a letter signed by 7 members of the House State Affairs Committee. So you all can look in this docket and see that letter that was filed, I believe, early this morning.
Shannon Caraway, you could.
Yes, Shannon Caraway with the Yalik Development Partners. I'll try to give back some of the time you graciously gave me earlier, longer than I needed or deserved. We filed comments in 54-481 yesterday on just narrowly one topic that I want to try to focus on here, and that's with projects that already have signed interconnect agreements with their utility, that those signed interconnect agreements be respected as they are for those that, most of these will be base load projects. And so consider the example I gave you earlier of our project, something signed in November of 24. We're trying to hit an in-service date of November of 27. We've been through both an RPG submittal and the other, the Picker 115 process. We've been through all those things and we've got written customer obligations that we signed on the back end, and you got financing for all of this, to then also be asking these base loads to open up, sign new agreements for a rule that's not even final. And to do so in such a short period of time is extremely difficult, almost untenable. So our request is that for base loads at a minimum, anybody that has signed interconnect agreements that they've already executed, those be honored without opening those up, and apply to new ones going forward from the time that you pass the rule. And with that, I'll yield back.
Thank you, sir. Commissioners, any questions, thoughts? Thank you. Item number 26 is project number 59053, pro forma wildfire mitigation plan development under 16 TAC 25.601.
Hey, good afternoon, Chairman, Commissioners, James Uten, Commission staff. Today I am presenting staff's pro forma wildfire mitigation plan and guidelines developed under 16 TAC 2560 subsection L in collaboration with our contractor, Bureau Veritas North America. Under subsection L, staff is authorized to develop one or more pro forma wildfire mitigation plans for voluntary use by entities required to submit a wildfire mitigation plan under 2560. On December 3rd, 2025, staff opened project number 59053 and filed draft pro forma plan guidelines, along with questions for public comment to solicit stakeholder feedback. On January 14th, 2026, staff held a public workshop to discuss key stakeholder issues and walk through the draft guidelines. Following the workshop, staff filed updated draft guidelines and provided an additional opportunity for stakeholders to submit written comments. After the close of the comment period, staff finalized the guidelines and used them to develop the pro forma plan itself. The guidelines and the plan are complementary documents intended to be used together. The guidelines explain the purpose and rule requirements of each section of the plan, while the plan itself provides a practical, fileable template for presenting wildfire mitigation information in a clear and consistent manner. In closing, staff presents the pro forma wildfire mitigation plan guidelines and plan as tools to assist entities in preparing compliant wildfire mitigation plan filings under 2560. Staff would like to thank stakeholders who contributed to the development of the guidelines and plan, and our contractor team for their support and collaboration. And with that, I am happy to answer any questions.
Thank you for that layout. A lot of great work on a very, very important issue. Commissioners, thoughts?
Yeah, just one, echo what the chairman just said. Appreciate you guys and all the stakeholder input you gathered for this project. Only question I have is with regard to timelines. Where are we at with regard to utilities and them filing either their version of the pro forma or using the pro forma themselves?
They can file today. The only prerequisite to filing their WMP is filing their notice of intent in project number 59402.
Okay, perfect. So we're ready to go, huh?
Ready to go.
Awesome. Thank you.
Just appreciate the pro forma template. Oftentimes there's guidelines that are laid out, but you don't really know, particularly if you're a small entity, where to start. And so I think this is particularly useful because it gives, as you said, a template so that everybody hopefully can submit early and get all the plans that we need in place and start, the mitigation. So thank you.
Okay, thank you.
Thank you all.
Great work.
Appreciate it.
And finally on the agenda, item number 35, that's project number 59557, streamlined complaint process, proposal for publication. Iliana, JB, good afternoon.
Afternoon, Commissioners. Can y'all hear me okay?
can.
Okay. Hi, this is Iliana De La Fuente with Commission staff. I'm here with John Lazier, and we are presenting item 35, which is our proposal for publication for project number 59557. The amended rules will streamline the Commission's complaint process for all utilities under the Commission's jurisdiction. The proposed process will bring the Commission in line with the complaint process of other agencies across the state. And complaints will now follow our information gathering and investigation process with our Consumer Protection Division. And should staff find any violation, those complaints would then be referred to our Enforcement Division. Further remedies can be sought in district court. And I'm here to answer any questions should you have them.
Thank you for that layout, Iliana. Commissioners, questions, thoughts on the PFP?
I just want to say congratulations. I know it's been a long process to get it to this point, but I appreciate y'all's input and work on it and foresight, like we mentioned about 4 or 5 hours ago.
I want to thank the staff for working. We had we went through some issues with them, and they were very helpful. I think these changes are going to make a real difference for Texans. So I thank y'all for working through it. It's great work.
Yeah, I think this is a great proposal, and just would encourage folks to take time, take a look at it, give us your thoughts and ideas, so that we can have something that is robust going forward and helps the ratepayers.
Thank you for your previous briefing and congratulations.
With that, I'll entertain a motion to approve the proposal for publication.
So moved.
I second.
I have a motion and a second. All those in favor say aye.
Aye.
Opposed? Motion prevails. All right, Mark, I don't know if you noticed, but some of us wore maroon today in support of you being up here. So
I did notice.
So, well done. This was no, Barstow, no hook 'em.
Thank you, Barstow.
So, again, a lot of big decisions today. Thanks for everyone's patience as we work through them. One of our longer meetings in recent memory, put a lot of really good work, and so thank you to everyone. With that, this meeting of the Public Utility Commission of Texas is hereby adjourned.